Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at large in the Ditkoff Commonwealth. Join in and give your attendance and you shall be heard. Now sitting Commonwealth and Massachusetts Court is open. Please be seated.
Good morning and welcome to the Massachusetts Appeals Court on this Monday, May 13th, 2024. I'm Justice Ditkoff. To my right is Justice Englander. To my left is Justice Smyth, and we'll be the panel for all 5 cases today. In the Appeals Court, we have a clock there. You'll have 15 minutes for each side. There's no rebuttal. The clock will show green. When it gets to 90 seconds, it'll turn yellow. When time runs out, it'll turn red, and it will start counting up. If it turns red, you can finish your sentence, but don't say anything else unless you're answering questions from the court, in which case, please complete your answer. We have read the briefs. We have looked through the appendices, so you'd be best advised to just jump right into your argument. We don't need the background. So, all that having been said, I'll call the first case, number 23P. 514, Commonwealth versus Maines. Counsel, whenever you're ready.
Good morning, Your Honors. May it please the Court, Rod Aresti for Mr. Maines. Your Honors, this is a case where all Mr. Maines wanted was to be sent back to the Nashua Street Jail, where he was supposed to be held pending his criminal charges instead of remaining committed at Bridgewater State Hospital. The primary question in this appeal is, did the Superior Court have the authority and jurisdiction to order Mr. Maines' recommitment in July of 2021? If it didn't, then the judge should have granted Mr. Maines' motion to dismiss. Now, the events that lead up to the motion to dismiss are a bit of a procedural quagmire, and I've detailed that in my brief. So just to summarize quickly, Mr. Maines had been committed and recommitted under Section 18 with no apparent hearings or mental health counsel from 2014 to 2020. In 2020, he finally did receive the benefit of mental health counsel, and that counsel filed a motion to rescind the previous commitment order from June 2020. At the hearing, the lower court agreed, and as did Bridgewater State Hospital. They called the past procedure, quote-unquote, problematic. So the court rescinded the prior commitment order dated June 17, 2020, but instead of discharging Mr. Maines back to jail, the judge made a ruling that Bridgewater's petition shall remain valid as long as the hospital updated its evaluation within 30 days.
And your position is that the petition was invalid. The petition had been filed in 2020?
It's part of my position.
Was invalid, yes. Why?
Yes, Your Honor. The court had no authority to do this because under Section 18, MGL 123, Section 18, that requires that the court must receive an evaluation before a petition may be filed. The lower court basically flip-flopped it.
Had they received an evaluation when the first petition was filed?
They had, but the first petition was, the evaluation
when
was
the petition was initially filed and the commitment was done back in whatever it was, June 2020.
June
right?
17, 2020. There was a valid petition.
There was also an evaluation at that time.
There was also an evaluation, but it was also adjudicated on, Your Honor. It was ruled on. Then the court order was essentially vacated, and then they resurrected the petition from. I mean, the date is unclear on the docket, but I would guess it's somewhere in May of 2020. So in January of 2021, the motion to rescind, Mr. Maines' counsel at the time said, all you have to do, Your Honor.
Basis for the rescission is there was no hearing, there was no counsel.
Correct.
Okay. So then the judge says, you're right, they didn't follow the procedure, there's no hearing, there's no counsel, but the petition, which had been filed 6 months earlier, still stands. You say the petition fails because
the evaluation is stale, Your Honor, and you have to follow.
And that's based on what case law? Or what statutory provision?
Section 18, 123, Section 18, the specific language says, after a medical evaluation, a written report shall contain an evaluation and be sent to the court and the person in charge of the place of detention. At that point, a petition may be filed. not the other way around. So once that petition is stale, once that petition was adjudicated on and vacated, the only solution was to send him back to jail. If Bridgewater wanted to recommit Mr. Maines, and it's apparent that they did, they had to start the process anew.
Usually when a hearing's done improperly, we redo it. Why is that not the case in mental health actions? I mean, if we reverse here,
Because they kept Mr. Maines committed for another 30 days, Your Honor. And the goal in the case law that I cite in my brief is to minimize that commitment. Mr. Maines only has two options.
A statutory provision that tells us how long he can be committed without a proper commitment order?
I'm sorry, Your Honor.
Is there a statutory provision that tells us how long he can remain committed without a proper commitment order? Like how quickly do they have to act? Is there a 14-day provision?
There's a case, Your Honor, that says he may be held for a brief detention. And in that case, and I'm sorry, I don't remember the name of the case. I'll look it up for you. But in that case, that's in my brief, the case says, or the facts of that case, the brief detention was only 1 or 2 days. This is 30 more days, Your Honor. And
Was there any objection to the 30 days?
in the motion to dismiss, yes, there was, Your Honor. The motion to dismiss that was brought in July of 2021.
Right.
Essentially said, this court has, or the Superior Court has no jurisdiction to
Leave aside the jurisdictional question. Was there an objection to the length of time that the judge gave for
the motion? It cites the same case where it says that a patient may be held for a brief detention.
right, but when the judge says February 25th, 2021, I thought that counsel agreed to that date.
Right, but the motion that is on appeal today, Your Honor, is not the motion to rescind. The motion to dismiss in July of 2021 states that the court did not have jurisdiction to keep Mr. Maines in.
Is there a notice of appeal filed after that January 21st order of that decision?
There was a notice of appeal on July in July of 2021.
So that probably isn't valid to raise an appeal of the January 2021
Well, Your
order.
Honor, jurisdictional issues are never waived. So if the court didn't have jurisdiction, it didn't have jurisdiction.
We're confusing so many different components to this, counsel.
I apologize, Your Honor.
And honestly, it's extremely confusing, at least to this judge. Just, reading the statutory language. Let me ask you a question sort of preliminarily, because there's a reference to Section 16 in somebody's brief. Has your client ever been determined to be incompetent to stand trial?
Never, Your Honor.
Why hasn't he been tried?
He's been committed, well, first, like I said, he was committed from 2014 till 2020.
Is there anything that says he
Recommitted.
can't be tried because he's committed to Bridgewater? If there's no determination of incompetency?
They had scheduled competency hearings, but they kept getting continued.
Counselor, he
At
wasn't,
the agreement of defendant.
Counsel, he wasn't found incompetent in February of this year?
He was, so after he's now back, he was released, after this commitment, he was released back to jail, and then recently recommitted on another Section 16.
So he has been found
competency
incompetent
evaluation.
now?
I believe that's still pending, Your Honor.
Well, he can't be determined to be incompetent under sections, he can't be put in under Section 16 unless he's been determined to be incompetent to stand trial, right? Or
I believe there's an evaluation. They haven't found him.
Okay, I guess that's for
I
another.
thought there was a 6-month commitment under Section 16 on February 29th, 2024.
One moment, Your Honor.
Wouldn't that require a finding of incompetency? And that's on appeal, too.
I'm sorry, what was that date, Your Honor? February 24th?
29th, 2024?
Yeah, he can't be committed under 16 the way I read it until he's determined to be incompetent.
I have correct. A petition filed for commitment on February 29th, 2024.
So when was he released back to Nashua?
The release back to Nashua?
Yeah.
Your Honor? He was released after this appeal was filed.
Okay, so why isn't it moot?
It's not moot, Your Honor, because, again, there's, Mr. Maines has the right for commitments to be appealed, so it can erase the stigma that's attached to it. I believe that's case law too, as well. So commitment appeals are never moot, Your Honor. Again, I'd just like to point out that that petition that we're talking about had already been adjudicated and obviously rescinded 6 months later, but after the court had rescinded it, like I said, the evaluation was stale, so now we have no commitment order to keep Mr. Maines in Bridgewater past those 30, or
Counsel,
for those
before we
30 days.
run out of time, I wanted to make sure we get to the notice of appeal here, because the notice of appeal isn't signed by the defendant and isn't signed by his lawyer. So how is it a valid notice of appeal, the July one?
July of 20,
Or, sorry, it's March? No,
There's
the
a
one
notice-
filed in August 2021. I don't know why
August
it's dated March.
2021. Well, I'm sorry, Your Honor, was that the appeal in the appendix?
Yeah.
I wasn't aware that it wasn't signed, but I might have, I'm guessing I might have put the wrong appeal.
I didn't find one that was signed by the defendant.
Okay.
When I looked. Doesn't mean I'm not missing it.
Yeah, I'm not,
Do you think this notice of appeal is valid when it's signed by someone who doesn't represent him and doesn't say it was authorized by him?
I believe that the appeal, the notice of appeal is valid if it's signed, Your Honor. I just don't have it in front of me, I'm sorry. I wasn't prepared to take a look at that one.
Okay.
So can we, I know that what you want to talk about is jurisdiction, so can you articulate your jurisdiction, the logic of your jurisdictional argument, please, so that I have
So
it
the lower court allowed this petition to stand for 30 days. It gave Bridgewater 30 days to file the updated medical evaluation, and Bridgewater didn't even do that. They filed it 35 days later. Now, the case law...
That your jurisdictional argument?
This is part of, yes, Your Honor. So
They lose jurisdiction because they gave them 30 days and instead they took 35?
time limits, yes, Your Honor. Time limits under Section 1, MGL 123 are jurisdictional.
What says
It should be
that? What says they're jurisdictional? I know they're mandatory.
That's, it's the SJC case, Hashimi versus Khalil.
That case says they're mandatory, it doesn't say they're jurisdictional.
It also says that time limits are jurisdictional, Your
Where does
Honor,
it say that?
and they're to be strictly construed.
Well, what does that mean, time limits are jurisdictional?
Once that petition is filed late, the lower court, the Superior Court, lost jurisdiction of the
Did
case.
it lose
So the
jurisdiction to
only-
determine whether it was filed late?
They lose
Jurisdiction
jurisdiction
is
to
just
commit.
power. That's all it means, the authority to make a decision.
Yes, Your Honor, but
Okay.
this is the whole thing. We're talking about committing someone, removing the liberty and freedom that they have, although granted, he's
Right,
going
but I
back
mean,
to...
the argument that you're making now is just a time limit. I thought that the argument you were making, this is why I asked you to articulate it, I thought the argument you were making was based on the statutory language that doesn't talk about, in a recommitment context, which court should get the recommitment proceedings for a pretrial detainee.
That's my other part, Your Honor. I'll move on to that part for you as well.
But, so there, I want to make sure I understand. So you're saying there are two jurisdictional points. One is the statutory language. Another is something to do with the time limits for ruling on a request to commit.
Yes, Your Honor.
That failing to rule on a timely basis on a request to admit deprives the court of jurisdiction?
Failing to submit the medical evaluation within 30 days, if the court had the power to even grant those 30 days, once that evaluation was filed late, the petition is invalid, and the Superior Court no longer has jurisdiction. The only thing they can do is dismiss him and send him back to jail.
Well, how do they have jurisdiction to send him back to jail?
They have to dismiss the case, Your Honor, and Bridgewater would have to start anew under Section 18. The other part of the argument, and
Who actually enters, I'm sorry, I just don't understand all the nuance of this. Who actually enters the order that he should be sent out of Bridgewater and back to jail? Is that an order that the Superior Court would enter?
Who enters the order that he should be sent? If he's dismissed, he must be discharged from Bridgewater and transferred back to his place of detention.
I guess the question is, does the way it works is Bridgewater gets a notice, this commitment order is now vacated, and then Bridgewater says, okay, well, we got to send him back to Nashua. Or does someone send an order to Bridgewater saying, send him to Nashua? Which of those two things happen?
Once there's no commitment order, he must be discharged.
I understand, but how does it happen practically? Does the court send an order, send him to Nashua, or does the court just send an order saying, no more commitment to Bridgewater, and then then Bridgewater figures it out?
I think Bridgewater figures it out, Your Honor, once the motion to dismiss is granted.
Yeah, I'm interested in your jurisdictional argument on your statutory interpretation. And Section 18A refers to an instant, or the initial hearing, excuse me, the initial hold for 6 months. Or first there's an order. It can be by the person in charge of the place of detention. Then there's a petition. And if the petition is granted by the court can grant it for 6 months, correct? That's the initial hearing?
Correct, Your Honor.
And you would agree Superior Court has jurisdiction on that initial hearing?
On the initial hearing.
But after that initial hearing, default's maybe not the right word, but 7 and 8 control.
Says
correct?
That he can be recommitted for up to 1 year under the provisions of Section 7 and 8.
And 7 and 8 specifically require the hearings to be before district court or a juvenile court, correct?
Correct, Your Honor.
So when was the initial 18?
The initial 18 was 2014.
2014, correct? So in July or in February Justice Sanders rescinded the order but allowed the petition to stand. Correct?
Yeah.
Was that in February? Was that?
Yes, Your Honor.
I have my
That's right.
timeline
That's
here.
right, February of 2021.
And there was some conversation in that hearing where your client did contest whether that petition was valid. But are you saying that petition there, that wasn't an initial hearing, that should have been brought under 7 and 8?
That should have been brought under 7 and 8, Your Honor. So that goes back to my jurisdictional argument that, part of the argument is if the petition had to be brought under 7 and 8, and that statute is supposed to be strictly construed, then that petition had to be brought to the district court.
And does that allow for an absurd result if somebody's charged in Superior Court, the initial hearings in the Superior Court, they're held?
I don't believe so, Your Honor, because Section 18A, and if I can turn real quickly to that, Section 18A says the provisions of 7 and 8 would control and shall be valid for up to 1 year. And then you have, I think it's...
Whoa. I don't see anything in 18A that says the provisions of 7 and 8 control. What I see is shall take place under the provisions of Section 7 and 8, which is the way you quoted it earlier. Have I got it right?
You've got it right, Your Honor.
Okay, but why do we assume that means that you have to import the jurisdictional limitations of 7 and 8 when you've got an explicit jurisdictional provision that allows the Superior Court to enter the original commitment order under Section 18?
Well, Your Honor, if the statute is supposed to be strictly construed, then
I don't understand why strict construction would lead me to the notion that only the district court can do this. What is strict about that?
Your Honor, so if I can just quote from my brief, Pembroke versus DL states, "The right of an individual to be free from physical restraint is a paradigmatic fundamental right. General Laws, Chapter 123 governs involuntary commitment due to mental illness, and this may curtail that freedom, but only in particular circumstances and by way of specific procedures designed to protect due process rights."
And Superior Court isn't designed to protect due process rights? I don't understand why it's more lenient to the defendant to switch courts from the one he's already in.
Your Honor, he's been committed and recommitted. His due process rights had already been violated, but the reason is because you have to protect his fundamental right to be free from restraint.
Why is the district court better able to do that than the Superior Court?
The statute says he must be committed under 7 and 8. Under 7 and 8...
Under the provisions of 7 and 8, so we know we use the standards of 7 and 8, but it doesn't tell us what court.
Well, I think now, Your Honor, we're just picking provisions. We're not taking the statute as a whole then. I think that...
If I look at the statute as a whole, I see it talks about, hey, if you're found incompetent, you go to district court. If you've already been convicted, you go to district court. And if you're competent but still pre-trial, you stay here. That's what it seems to say.
I think, Your Honor, that this court has an opportunity to clarify that language, but at the same time, again, we're talking about someone's paradigmatic fundamental right to be free from restraint. And Mr. Maines had been there under problematic procedure for a long time. So at this point, when he's committed and recommitted under Section 18, there's a case, I believe it's GP, in the matter of GP, that says you can't be recommitted under Section 18. You have to be committed under the sections of provisions of Section 7.
I don't think anyone questions that fundamental rights are involved. But when you're arguing jurisdiction, the core question is what Justice Ditkoff just asked, which is, why is it that we assume the statute takes away from the Superior Court the ability to do what it could do the first time around? Well, that doesn't seem to me, at least, to have anything to do with your client's fundamental rights. He has due process now. He didn't have it before, but he has it now before a Superior Court judge.
Well, again, getting back to the language of Section 18 and 7 and 8, Your Honor, it's if you look at a similar statute, Section 16, you have the same thing, that they can be committed under the provisions of Section 7 and 8. However, it also talks about the requirements for a finding under 7 and 8, as long as that person is incompetent. We don't have that here. And we have case law that says you must strictly construe the statutes. And if you're going to strictly construe Section 7 and 8, then the Superior Court does not have the jurisdiction to commit Mr. Maines under Section 18 again. And he had been committed and recommitted under Section 18 over and over for several years before he had mental health counsel.
Thank you.
Thank you, Your Honor.
All right, we'll hear from the department. Mr. Conlon, whenever you're ready.
Yes, Your Honor. Your Honor, my name is Robert Conlon. I represent Bridgewater State Hospital in this appeal. I would ask the court to affirm the commitment order of July 29th of 2021, as well as the motion to denial of the motion to dismiss Bridgewater's petition of May 27th of 2020. Your Honor, essentially, this case involves a full review of the record shows that Bridgewater had jurisdiction to file Superior Court petitions for recommitment under Section 18. In my brief, I pointed out how Mr. Maines came to Bridgewater from the Worcester House of Correction under Section 18A. He was evaluated by psychiatrists there, found in need of mental health treatment, sent to Bridgewater. And the statute is written in such a way, Your Honor, that it has a predicate of custody status. Mr. Maines was facing charges of aggravated rape, kidnapping, armed robbery. He had a bail status at that time of $50,000. So he was a pretrial detainee, Your Honor. And at the conclusion of his first initial 18 commitment to Bridgewater, and that would have been in the spring of 2015, Bridgewater filed a recommitment petition in the court which had jurisdiction of this case, which is a criminal court. And that language is straight from Section 18, Your Honor. Much of what the questioning that we've just heard concerns the role of Section 7 and 8. 7 and 8 is incorporated into Section 18, Your Honor. It doesn't change jurisdiction.
Well, let me ask you this. There's really one case on this, which is KJ. And in KJ, the one-year hearing wasn't held in the courts with the criminal charges. It was held in the Brockton District Court, which I presume is where the facility was, not in Worcester District Court or Worcester Superior Court. So why doesn't that tell us that the answer is you go to the district court where the facility is?
Well, Your Honor, in the case of KJ, he had charges pending in both the district court, the Worcester District Court, as well as the Superior Court. And I think it was more a process of just timeliness, Your Honor, that the district court case was up first and Bridgewater filed a petition in the Brockton District Court, sitting by designation for the Worcester District Court. So that's the only reason that that happened.
You know it was sitting, or you're just assuming? You know it was sitting as a Worcester District Court, or do you know that, or you just think that's probably what happened?
Oh, no, Your Honor. I may have included in my appendix, but there is a ruling from July of 2014 where essentially the Brockton District Court sits by designation for the district court.
Yeah, I know that happens.
Yes. So in our case, the jurisdiction has always been the Suffolk Superior Court because that's where the criminal charges with Mr. Maines are pending. Mr. Maines has no district court criminal charges here to cloud the issue, Your Honor, at this point.
Counsel, do you concede that Mr. Maines' rights were violated in 2014, 15, 16, 17, 18, and 19?
I don't, Your Honor, and for this reason. First, I believe those commitments were never appealed, so essentially they've been waived. Number two, the record wasn't adequately developed in this appeal to reach that far back to show that. I went back to show how Mr. Maines came to Bridgewater originally, to show that he legitimately came from a Worcester House of Correction, a place of detention for mental health evaluation, and he had outstanding charges.
Okay, but at least in 2020, he had no counsel, and he had no hearing, right?
Well, Your Honor, that argument has gained some currency, but it's not accurate. He was represented by criminal defense counsel, and that's not a disqualifier to...
Was there a hearing as to his competency in 2020? Or as to whether he should be committed?
Well, Your Honor, the issue of competence is very interesting. Much earlier in his time
I'm
at Bridgewater...
sorry. You say that he had a lawyer.
Yes, Your
My
Honor.
question, I thought, was pretty straightforward. Was there a hearing as to whether he should be committed in 2020?
There was no hearing, Your Honor, no.
Okay.
But by the same token, Bridgewater...
But the statute says there has to be a hearing.
The statute permits a hearing, Your Honor, but under Section 6B, hearings can be waived or they can be not contested. That's just a common occurrence here, Your Honor. There isn't always a hearing per se. But my argument is that we don't have adequate development of the record for those years between 2015 and 2020 to show that Mr. Maines indeed...
No, I understand that point. I understand that point. Thank you.
Oh, you're welcome, Your Honor. The other point I wanted to make, Your Honor, is that Bridgewater, when we filed our petition in May of 2020, notified Mr. Maines' criminal defense attorney. So there was notice of the petition being filed. I would add, Your Honor, that when we get up to the motion to vacate Mr. Maines' order in October of 2020, and then we have the hearing in January of 2021, the judge was very clear that while the order was vacated, to give Mr. Maines, and I think this is a judge displaying or extending, essentially wanting to do the right thing here, crediting Mr. Maines' claim that he wanted to have a hearing. When the judge did that, she was, and the court has mentioned this, she was explicit that the petition itself was properly filed. Now, the question has come up, how does a patient remain at Bridgewater on a pending petition? Chapter 123, Section 6A permits someone to be held at Bridgewater while pending hearing on a petition. We've heard much of the 7C provision.
Is there a time limit on that?
There is no time limit, Your Honor.
That can't be right as a matter of just in the air, counsel. There has to be the Constitution will place a time limit on how long you can hold somebody without an adjudication that they should be committed.
Well, Your Honor, the time limits come in different form. Again, Section 7.3 permits a hearing must occur within 14 days unless it's waived.
Right.
Beyond that, Your Honor, the respondent can request a hearing, request a continuance. This is a case of NL, and that must be granted. But, Your Honor, essentially, at that point in time, the standard is such that continuances are granted only for good cause. If a patient wants to take time to prepare for defense for his matter, that's his right, Your Honor. If he insists on
But
going
we don't
forward-
have evidence of that with respect to what happened, and I'm going to get the dates wrong, but there's a point at which his lawyer comes before Judge Sanders and says, hey, my client was committed improperly, and she says, you're right, right? And then, instead of being sent back to jail, he's kept there for 30 days, right?
Yes, Your Honor.
And is it your contention that I will find in the record that defense counsel agreed to that?
Well, yes, Your Honor. When they were talking about a next date, I'm sorry, Your Honor, I want to be accurate about this. At this point in time, in January of 2021, we're talking about Mr. Gillis, who was actually serving as not defense counsel, but as mental health counsel.
Okay.
Essentially. And he did agree to the next date of February 25th of 2020.
But he did want his client sent back to Nashua in the meantime. He agreed to the
Yes.
date, but he seemed like he didn't agree to the place.
Yes, Your Honor. He wanted Mr. Main's return to the House of Correction. However, as I cited Chapter 6A of Chapter 123, where the petition was legitimately filed and proper in the court's opinion, there was that ability to retain Mr. Main's at Bridgewater. And it also became a practice.
Whoa. For more than 14 days?
Yes, Your Honor, because...
How?
Well, again, Your Honor, the petition was filed in May of 2020, so the 14 days runs from that point forward, not from the January 21st date, Your Honor. So we already have a petition that's legitimate.
So we've missed the 14 days then?
Well, Your Honor, the 14 days, again, that accrued in May of 2020. The point I wanted to make, too, Your Honor, is this is an exceptional case in the sense that commitment petitions usually aren't vacated in this fashion. What usually happens is someone is committed to Bridgewater, and their avenue for redress, say, as was pointed out, Mr. Maines wanted to return to jail, he would need to file an application under Section 9B of Chapter 123, essentially saying, I no longer need to be civilly committed, I can return to the jail. The Superior Court is tasked with marking that up for a hearing within several days.
Okay.
I know
It's great that you guys are as steeped in this, the way these things are done, but I'm still confused because I'm looking at a statute that says that he needs to have a hearing within 14 days, right? And you're saying, oh, he did because 6 months earlier he had a hearing on something that has been vacated by the judge because it was illegal, okay? And that's the only hearing he got. So how does the judge have now authority, having vacated it, to say 30 days?
Well, Your
I
Honor,
don't see that in the statutory language that says shall be commenced within 14 days
well,
of
Your
the
Honor,
filing of the petition.
I don't want to sound redundant, but essentially she found that the petition was legitimately filed. There was an agreement among the parties that in order to, and the judge didn't order Bridgewater to file a new Section 18 petition. She ordered that Bridgewater update its evaluation, which Bridgewater did.
The problem I have with that is I think this 14-day provision is so that you just don't hold somebody without a court order, okay? And the notion that the judge has the authority to hold that person for 30 days without the ability to enter an order because she doesn't have an updated review seems to me to be inconsistent with the statute.
Well,
Leaving aside the question of whether this is jurisdictional.
Your Honor, I respectfully would say that what we had at this point was a major advancement in terms of the respondent's agenda. He had filed a motion for a new hearing based on the petition that was legitimately filed. He wanted mental health counsel appointed. He had that at this point. Going forward, the court conferred with the parties, and that's in the transcript, in terms of the practicalities of a next date. It was agreed on for next date. So I'd say, Your Honor, to the extent that you may be concerned about the 14 days being applicable at that point, there was a waiver of it essentially by Mr. Mains's mental health counsel, who agreed on the next date.
Has Justice Ditkoff accurately represented the record, which is that he asked to be sent back to, he didn't agree to 30 days in Bridgewater, he asked to be sent back to jail?
Yes, Your Honor. In the court, the lower court's assessment of that request, Your Honor, was very compelling. Essentially, Mr. Mains had been at Bridgewater for a number of years. It was in the midst of a pandemic. There was evidence of him being easily destabilized by a change of environment. And for all those reasons, Your Honor, it made sense to maintain him at Bridgewater.
Is that all in the record, too?
It is, Your Honor. And also going forward from that point, there has been a claim that after the petition was filed on February 24th, he requested a hearing within 14 days, but the record reveals, Your Honor, that he didn't. One of the first things that happened was that Mr. Gillis was fired by the next date of February 25th. The next counsel came in, requested IME funds.
And the year is 2021, right?
Yes, Your Honor. And next attorney, mental health attorney appointed, requested funds, was looking for a next date. It's argued in the brief of the appellant that that didn't signify a request for a continuance. I would submit, Your Honor, that if someone files a request for an independent medical examination, they are contemplating a future date, not an immediate date for hearing. So the record is replete with Mr. Mains going through numerous counsel, Your Honor. One counsel comes in, I think maybe the third one, essentially says that Mr. Mains wants to have a hearing, but with successor counsel. So the record bears up, Your Honor, that there was a waiver of this 14-day requirement, even on the second commitment petition, Your Honor. So
It seemed like on several of those dates, you personally opposed the continuances, asked for a quicker one. Could you walk us through your reasoning there?
Yes, Your Honor. Well, there were a couple of things going on in the case, Your Honor. I got into the case in March of 2021. I picked up from another counsel, but Bridgewater had filed a petition in the district court for an 8B order, for a Rogers District Court order, and it was in our interest, given Mr. Mains's presentation, to go forward on that. But we can't go forward on an 8B petition until there is a commitment order. So it was in the hospital's interest to move this case along, and that frequently does happen. The hospital doesn't like to drag these hearings out any more than anyone else because they involve patient care, and we, of course, are tasked with trying to improve mental health patients in terms of their condition and how they're presenting. Your Honor, the other points I just wanted to update you quickly is that, yes, Mr. Mains was discharged from Bridgewater in June of 2023, and he was stepped down to a Department of Mental Health facility. My understanding is that he remained there for a couple of months. He was returned to the jail, and then he came back to Bridgewater in January of this year. He was committed on February 29th of 2024. He had represented by criminal defense counsel. He then retained mental health counsel, who now wants to have essentially a hearing on the matter. So we are currently awaiting.
Do you agree with your brother that the case is not moot? Because I think, as your brother put it, any commitment order never becomes moot.
Well, there is a long line of case law, Your Honor, essentially saying that an individual has an interest going forward. The person that has been committed has an interest in the matter being their appeal going forward. So I do have to concede that point, Your Honor.
What do you think of the, well, I suppose it could be different where there are 10 commitment orders and we're only appealing one. But what do you think of the position that the time limits themselves are jurisdictional and deprive the Superior Court of the authority to act?
Well, the 14-day requirement is there, Your Honor. It just doesn't apply in this case. Citing Hashimi v. Khalil, that's a fundamental case, but it doesn't apply to the circumstances of this case.
Are there cases, does that case say that the time limits in Section 18, or that's actually not Section 18, but in this chapter are jurisdictional?
It does, Your Honor, but it has to be put in context that it's only a civil commitment. For example, if you jump to Section 16, for example, a 16B petition, there has to be that initial finding of incompetence to stand trial. So oftentimes that will not happen within 14 days if particularly the Commonwealth or the defendant wants to contest the issue of competence in the criminal court, Your Honor. So I think the context is everything here, Your Honor.
The 14 days can be waived.
In what circumstances?
14 days can be waived by defense counsel.
And often is, Your Honor, if they
Yeah.
file for non-independent.
Thank you.
Thank you, Your Honor.
Well,
Counsel, I wanted to ask you a few questions while we still have you. First, I think an easy one on Record Appendix 1, page 70. Is that the petition at issue? One of the reasons I asked is it's undated.
Is there any indication of a date on it at all, Your Honor?
No, that's why I'm raising the question. Well, let me go to my second question. What standard would you apply to Section 18, the initial commitment? So first, the supervisor of a place of detention would have a medical evaluation, psychological evaluation, and then there'd be a report, then there'd be a petition. So at the petition before the court, what standard does the court use? Unlike 7 and 8, it doesn't set forth a standard for which the court should determine whether or not he should be detained for or held for 6 months under 18A.
So if I understand your question, Your Honor, basically you're asking for the subsequent petition?
Yes.
Yes. Well, Your Honor, it would basically nullify Section 18 if after a 6-month commitment, someone had to be returned to the place of detention to be just destabilized.
No, I mean, to allow for that 6 month, that standard. What does the judge have to find and say, I'm going to commit him under 18A, he or she, for 6 months because?
Well, those are the standards set out in Section 7 and 8, Your Honor, mental illness, need for hospitalization, and more particularly.
Where does 18A for the initial hearing cite back to 7 and 8, that standard?
Toward the bottom portion of Section 18A, Your Honor, essentially incorporates Section 7 and 8 into the chapter, but as we discussed earlier, it doesn't direct that the hearings then move to the district court. And that's fundamental to both Section 16 as well as 18. They incorporate 7 and 8 into them for the findings of mental illness, need for hospitalization.
Okay.
Can I swing back to Judge Smith's question? So on page 70 of the appendix, there's this petition, and the page before that is a fax transmission report that's dated February 24th, 2021. Do these two things go together?
Yeah, they should, Your Honor. In fact, our letter was dated February 23rd, but it wasn't faxed until February 24th at 9:30, so that would have been the February petition, Your Honor.
Right, the letter on the fax report is dated the 23rd, like you said. So those are connected, those two things.
Yes, Your Honor. Yes, Your Honor. Thank you for helping clarify that. I appreciate that.
Right. Well, thank you both. This is a very interesting and important case. We will move on to the second case, number 23P807, Commonwealth versus Belnavis. Let's let your friend get set up. It's nice to see you back. Welcome back to the John Adams Courthouse.
Thank you, Your Honor. Good morning. May it please the Court. Mitchell Kosh on behalf of Mr. DEJAN Belnavis, the appellant in this case. At trial, 2 officers from the Worcester Police Department gang unit identified Mr. Belnavis in a series of photographs and video. The admission of that testimony was prejudicial error. It was error because the officers lacked sufficient relevant familiarity to render their opinion as to who was in the video helpful to the court as lay opinion testimony. In fact, if this
Counsel, I don't normally interrupt this early, but you are talking prejudicial error,
Yes,
and
Your
it's
Honor.
not obvious to me how this claim is preserved.
Well, Your Honor, there was some trouble with the transcripts, and when the counsel objected, he went to sidebar, and those sidebars are inaudible. So before bringing the appeal, I met with counsel, and I met with opposing counsel, and we entered a stipulation as to the content of those sidebar conversations. And in those sidebar conversations, you'll find that the counsel objected to the testimony of the officers and the identification of the officers.
I think
Did
I
he
see
object
what
to
you're...
the use of, did he object to them identifying themselves as members of the gang unit?
He did, Your Honor, prior in the motions in limine beforehand.
Yeah, so this-
there was a whole debate about
The
that.
stipulation says there's an objection to the identifying him as a member of the gang unit. But is that the time where he does the ID on the photos? Seems like a different part.
I believe this was preserved in the motion in limine, Your Honor.
Well, the motion in limine, the judge didn't rule for the Commonwealth. The judge said, I'll allow the Commonwealth to elicit testimony to see if they can establish a foundation to meet the factors necessary. Defendant will have a full opportunity, if it believes the foundation has not been met, to raise the objection again. So I don't see how that would preserve without a future, I mean, that's the only ruling you can make, really, right? Let's see what the foundation is.
Yes, Your Honor. I'd need to look again at precisely where his objections were in that. My understanding from the transcript was these were preserved errors. I'm happy to submit a 16L letter with more clarification on that, looking back to the transcript.
Well, I mean, I read the transcript this morning, but I'm not as steeped in this as...
Yeah, I mean, there's an objection there when it starts, but you say that he argued at sidebar the testimony was unduly prejudicial because it implied Mr. Belnavis' membership in a gang to the jury, and that it was not relevant to the basis of the officer's lay opinion identification. It doesn't say he said the foundation wasn't met in your stipulation. I don't know if I'm missing something.
I think that I would need to look back at the transcripts again.
Well, in any event, even if it's not preserved, you still get to raise it on substantial risk, so you should
Sure, Your Honor. And
go forward in any event.
would take that opportunity to turn to the prejudice in this case, which I think is substantial from this testimony. I mean, this was the sole issue at trial that went to the jury, the identification question, and there was no other corroborating evidence that put Mr. Belnavis in the Walmart at this time. It was the videos and it was the testimony of the officers. So in that instance, I think there's a substantial reason to find prejudice. I also think we have some sense that the jury was looking at this. They asked to see Mr. Belnavis' identification, and I think there's a fair inference from that there was debate in the jury room, perhaps that they attempted to solve by asking for the ID. The prejudice is further compounded by the fact that the officers were identified as police officers. Appellate courts have been warning trial courts for 50 years not to identify officers.
What case would you rely on for that? I mean, don't they have to identify how they know the guy?
I would look to Butcher, Your Honor. That's a 1977 gang robbery case where the courts say that.
From which court?
I believe that's a 10th Circuit court. But the SJC says this repeatedly. They say there's an increased risk of prejudice when the officers are identified. This court said
Maybe
in
so,
Pleas.
but I struggled as I read your briefs to try to figure out how else they were supposed to do it. Were they supposed to put these people on? I mean, they're not necessarily going to get any witnesses from the Walmart, right? But they need to identify who it is who's in the video. Turns out that they've got people on staff who know him, okay? They're going to put this person on. I mean, what are they going to do? This is some person who just walked off the street. Do you recognize the person? They can't, I mean, they have a right, it seems to me, to identify a foundation for how the person knows that person.
I think in some of the federal cases, Your Honor, when there's a parole officer, they say, I know him through my work from my business, and they leave it at that. And then from there, they say...
A parole officer is a little different than police officer, isn't it? Parole officer tells the jury that the person is on parole. Police does not.
I think in this case, especially, Your Honor, once the officer identified themselves as members of the gang unit...
Right, but you have to leave that aside for me for a moment, because
Sure.
I am not yet convinced about whether or not that's preserved. I mean, I read the transcript this morning. The gang the fact that they're in a gang comes out without objection at all for both of them. The objection is subsequent, and I would have a hard time believing that the subsequent objection said, I want you to go correct that, Judge. Tell the jury to ignore the fact that they said they were in a gang unit. But we'll have to figure that out ourselves, it seems to me. Leave the gang unit part out
Sure.
What case are you relying on that says they couldn't even identify themselves as police officers?
I'm not saying necessarily, officer, that they can't, or Your Honor, that they can't do that, but that it's prejudicial when they do, and it increases the risk of prejudice in the case.
But isn't that partly your client's fault, that the people who know him are police officers because they've met him 4 times? I mean, I don't understand why that, and there are cases that say this as well. I mean, this is the risk of having a life where those are the people who can identify you.
Well, Your Honor, this is not a case that took place in a dark alley or a closed room. This took place at 10 a.m. in a Walmart. I think there's a lot of witnesses that the Commonwealth potentially could have gone to find, and the fact that there
But
were...
the defense doesn't get to choose what witnesses the prosecution chooses to put on.
No, but the prosecution is responsible for the prejudice that comes with those. And in Pena, in Wordsworth...
Unfair prejudice.
Sure, Your Honor. Unfair prejudice. And the unfair prejudice here on the identification issue is the risk that the jury is going to be swayed by the officer's authority, the imprimatur of their badge, and substitute the officer's opinion for the juror's opinion. And here, where there's no other corroborating evidence, that's a real risk in the jury room.
I guess that leads me back to the question, what else are they supposed to do? I mean, I guess, you would say, well, there were other witnesses there.
Well, I think, Your Honor, that they could have identified themselves, they could have taken the stand and not identified themselves as police officers, said, I have
knew
seen
them
this
from my business.
Sure. I've seen this individual 2 times in the last 4 years, and on that basis, on that flimsy basis, I think I can identify him in the video.
Do you know if they were wearing uniforms when they testified?
I do not believe that's in the record, Your Honor. I'm not sure.
I mean, just because they're wearing uniforms doesn't mean they have to say they're gang unit.
Yeah, right, exactly. Once they're identified as police, there's an additional prejudice that comes from not only saying that they're in the gang unit, but the specific ways they describe their duties. One officer stood up and said, my job is to identify gang members. My job is to follow up on gang violent incidents, and I know Mr. Belnavis from my work. That brought in all of the prejudice that courts often warn about with gang testimony, and it brought it into this case where there was a motion to exclude, more substantive gang evidence, and I think that colored the entire case by implication. That implication is clear. So I would also add that into the prejudice analysis, Your Honor. And whether we're under the substantial risk or we're under prejudicial error, depending on what Your Honor finds when you review the transcripts again, and I would argue that I think this error was preserved based on my reading of the transcripts. But either way, there's enough prejudice, I think, under either standard to conclude that this was error. And I would point again to the just the fact that this is unlike, say, Fisher or Pena, where there's substantial other evidence that ties the defendant to the crime. In Fisher, they said there's no prejudice here because we have CSLI, we have really incriminating text messages. He's driving a very distinctive car that has one of the quarters is a different color, and we've seen that on the surveillance video with the murder, and then we saw it the next day. So, there's nothing like that kind of corroboration, and so we have the videos, and we have the officer's testimony identifying him, and that's it. So in that context, I think the officer's testimony was prejudicial.
Is your position that the video clips were sufficiently clear that essentially, by having the officers testify, that would usurp essentially the function of the jury?
No, Your Honor, we admit that these videos fall into the middle ground where a lay opinion testimony witness could be helpful, but generally speaking, that requires a lot more familiarity under Massachusetts law. If this court were to accept the basis of familiarity that these officers had, it would constitute a new low watermark in the Commonwealth's cases.
How do we review that, though? That's an abuse of discretion standard, isn't it?
As to whether or not to admit the testimony?
Yeah.
Yes, Your Honor. And it was an abuse of discretion here. It was an error under the cases.
I know the person. I've met him 4 times in connection with my work.
Yes, Your Honor.
Not sufficient as a matter of law.
Not sufficient. When you look to pleas, the seminal case where this court looked at federal law and adopted their standard under 701 into our common law of evidence, the pleas court gives a sense of what it means by sufficient relevant familiarity. And in the cases it cites there, it says it's his girlfriend. He's known him 70. Another case, they said he's seen him 75 times. Another witness 20 times.
But there's nothing in pleas that says, well, 4 times is not enough.
No, Your Honor, we're drawing lines between the cases, and I think it's, there's a significant difference between this case and the best case that the Commonwealth cites, which is Cornegay, right? And in Cornegay, there's the officer observed him 6 times in 6 months, but the officer in that case had a very specific problem. He needed to distinguish Andrew Cornegay from his brother Andre Cornegay. And so in all 6 of those encounters, he is specifically looking to the defendant to distinguish him from his doppelganger.
And your contention is this objection was also specifically made to the court?
I'm sorry, Your Honor?
This objection was also specifically made to the judge. Judge, the knowledge that the basis for this, the foundation for their testimony, their ID, is insufficient under our case law.
He argues that it's insufficient under pleas, Your Honor. He argues that in his motions in limine. Yeah.
Okay.
If there are no other questions on the ID issue, I'll turn to the Brady violation. Your Honor, there was a Brady violation in this case that shaped the entire course of the defense investigation and potentially deprived Mr. Belnavis of a substantial defense. And under those circumstances, there's room to find prejudice here. What Mr. Belnavis had in the first video foreclosed a self-defense defense. What he saw in the second video made it possible. And in the middle of trial, the prejudice is measured by the delay.
But the problem is the second video didn't make it possible.
How so, Your Honor?
Well, he didn't get a self-defense instruction, didn't even ask for one based on the second video as far as I could tell.
He did, Your Honor. After his mistrial was denied multiple times, counsel said, I would like to argue self-defense, and the judge looked at the video and he didn't say it's inculpatory, not exculpatory, so you don't get a self-defense instruction. What he said was, I'm going to deny this without prejudice to any other evidence that the defense might bring. He said the video is not enough, and that additional evidence that he potentially could have found is the prejudice here, because...
But how do we know there is additional evidence out there? I mean, you got a new trial motion, so you had time to find it.
We don't in this case, Your Honor, and there's no new trial motion.
Oh, there was no new trial motion. Oh, I'm sorry.
No, this is the direct appeal. So I think that's that's a question mark in this case, right? We don't know we don't know, and the reason we don't know that is because the Commonwealth dropped this video in the middle of trial on defense counsel, a video that it appears the police had the day after the incident in Walmart.
So ordinarily we would, in order for you to show prejudice here, we would need some sort of offer of proof. Your position is, the way this happened, how is my prior counsel going to make an offer of proof as to what he could have proved? He didn't have the time.
That's correct, Your Honor. And there's a couple cases I'd point to Your Honor to, and for this, Commonwealth versus Vaughn. In that case, when the appellate panel said, it's clear to us to see how the defense could have changed. And defense counsel saw this immediately. He stood up and said, I would have argued self-defense. He said that in an affidavit sworn afterwards. And so this was not just in the heat of trial decision. So when you can see how it would have shaped the entire defense differently, I think there's room to find prejudice there.
They're flatly inconsistent.
Yes, Your Honor. And that's why yes, they're flatly inconsistent, correct. Thank you, Your Honor.
Thank you. We'll hear from the Commonwealth now. Whenever you're ready, Counselor.
Good morning, and may it please the Court. Jesse Crane for the Commonwealth, asking that you affirm the defendant's convictions. I'll start with the lay witness identification issue first. I would argue that the issue of level of familiarity was not preserved. In the motion session prior to trial, the ADA offered to conduct a voir dire for these two police officers to provide a basis of familiarity. The defendant basically argued that the videos spoke for themselves, and then the trial judge never had the opportunity to exercise any discretion because he basically said, I haven't seen the videos yet, and defense counsel was arguing that some of these videos and pictures were going to be objected to, so there was a possibility of them not even coming in at that point. He encouraged defense counsel to renew his objection upon the officers offering an identification, or before, and basically saying, let's hash this out at sidebar before these identifications are made so that we can assess whether the plea factors are met. I would argue that the plea factors were met. The officers did have sufficient familiarity. Pleas offers a multi-factor balancing test as to whether the opinions are helpful to the jury. The test is whether they are more likely than the jury to correctly identify the defendant from the pictures or the video.
One of the officers had met him twice. That's sufficient?
It's context specific, and I would say in this context there was enough in the record to support that he was familiar enough, because he testified he was in the defendant's presence long enough for someone to check his ID, and that was the same for Officer Denio, who was the first officer. He testified that he also had checked his ID in the circumstances where he had encountered the defendant. So I would argue that given the balancing of that familiarity against the lower quality of the pictures and the video, and the fact that the defendant was wearing sunglasses so his face was partially obscured, these were admissible under pleas. And I think it's worth adding a little bit of nuance to when courts have an issue with police officers identifying themselves as police officers, and that's when their familiarity is not based on their work. So one case that I cite, Commonwealth v. Carr, stresses that there the lay witness identification was problematic because the officer was familiar with the defendant from school, not from his work.
Well, that's what pleas says as well. Are you telling me if we go back and read the cases cited by the defendant, there aren't going to be any that say it would be better if they didn't identify themselves as police officers?
No, that language certainly is used by the SJC, and I agree that the SJC stresses that this needs to be used with caution, but this is not an absolute prohibition by any means. There are situations where the Commonwealth has to offer identification witnesses who are police officers who know the defendant through their work.
What about PINA that says for when it's police officer, there has to be some compelling reason?
I think the compelling reason is present here because these were the only identifications possible. There were no other eyewitnesses that the Commonwealth could offer in this situation. We had a non-cooperative victim, and the other people present for the altercation were never identified.
Is PINA a Massachusetts case?
Yes, it is, Your Honor. It's an SJC case.
Why, for me, the $64,000 question, why identify themselves as members of the gang unit?
Because they had to offer some sort of foundation for their familiarity.
They're police officers. Why isn't that sufficient foundation? This is my job. I've met them during my job. Why did they have to identify themselves as members of a gang unit?
Because their familiarity with the defendant, they testified, came about through encounters with the public. There was testimony when they introduced themselves that both officers said, a large part of our role is just walking the beat, interacting with the public.
Wouldn't the jury think that's true of a police officer whether they're a member of a gang unit or not? I mean, isn't it a fair point that by identifying themselves as members of the gang unit under these circumstances, the prosecution was telling the jury, this person is a gang member. That's how they met him.
I think in this circumstance, it would have been better not to say they were members of the gang unit, but this was a fairly oblique reference to gangs. I mean, there was no testimony that the defendant was actually in a gang. And the prosecutor, going to the issue of prejudice, the prosecutor never again mentioned that they were members of the gang unit, say in his closing argument. I recognize the concern, but I think under these circumstances where the prosecution needed to lay some kind of foundation to meet pleas, the prejudice was not overwhelming, and the probative value outweighed it.
So was the gang unit, was that preserved, an objection to identifying them as members of a gang unit?
I believe the reconstructed record does record that the defense counsel did object to that.
Not before the evidence came out, unless it was in a motion in limine.
On the specific issue of them identifying as gang members, no, that was not in a
As
motion.
gang unit.
Yes, excuse me. Yes.
That was not in the motion in limine?
It was not. That referred only to the defendant's membership in a gang. And there was a similar prior bad acts.
So then, put your guy on and you say, what's your position with the Worcester Police Department? No objection. I'm in the gang unit. What do you do in the gang unit? No objection. So how is that preserved?
I would say in these circumstances, then it's not.
There's some objection that comes later that we don't have in the record.
No, and the record was not reconstructed on that point.
The objection is, do you know him through your work as a police officer, which at this point means gang unit, right?
Yes, at that point in the testimony.
He doesn't mind the officer saying he's with the gang unit. What he objects to is connecting that to his knowledge. Is that how correct? That's the way I'm reading this stipulation.
Yes, I believe that is correct. But again, I mean, it goes back to the issue of the foundation. I agree that it would have been better not to mention the gang unit specifically, but this was also ties into part of the defense strategy, which was to criticize the police investigation. And in Officer Seru's testimony, defense counsel actually solicits from the officer who recovered the photographs and the video that he had referred the matter to the gang unit, essentially. So it wasn't exactly new information at the point that Officers Denio and Mazzoni were testifying that the gang unit had been involved.
So let me put some of my cards on the table. If there is error in the ID, normally I would figure out how harmful it was by looking at the close. And in one of the SJC cases, they said, didn't argue that in the close. But here, it seemed like the ADA argued that extensively in the close. These officers ID'd, and so therefore you know it's that person. Is there any reason why I shouldn't make that my determinant of how, I understand you argue it isn't error at all, but if it is error, is there any reason why that shouldn't be the touchstone of prejudice here?
I would say no. I would point first to the jury question, which I think strongly suggests that there was not a risk that the jury were basically substituting the officer's judgment on identifying the defendant for their own. I would say second, when you look at the context of what the identification was given in, it was given for exhibits 4, 5, and 7, which basically just show the defendant leaving Walmart. The jury still needed to make a determination as to who they thought was the person depicted in exhibits 1 and 6, where the actual altercation was shown, and the defendant's face is never really in frame. So even if the jury, basically blindly accepted the officers.
But if they don't believe that the person in the other videos is that, they've got no basis to believe he's the person in those videos, right? Like, is there any way they would find that he was the person in Exhibit 1 or 6 if they didn't believe the IDs for the other videos? Is there evidence of that?
I think they still could have. They saw the defendant in the courtroom. They could have made an assessment based on his stature, the way he moved, the way he looked, his hairstyle. There was still a basis for the jury to decide solely on exhibits 1 and 6 that it was the defendant. If there are no further questions on the identification issue, I'll move to the late disclosure. I think the appellate record before you is insufficient to determine that the defendant's trial tactics would have actually changed had this been disclosed in a timely manner. The video itself was the basis for the defendant making a motion to argue self-defense, which was denied. And the argument that he would have investigated further, I think, is belied by the fact that he had an opportunity after disclosure, when there was a continuance granted between the first day and the second day, to investigate the victim's criminal record if that was suddenly, a fact that he believed was important solely based on the fisheye video. And I would argue that...
Am I right in thinking, this kind of goes both ways, that we don't know what he did during that break?
No, we don't know. We just know what's on the record. And I think there were other options that defense counsel had. He could have moved to suppress the video. He could have moved for another short continuance to investigate further. He could have asked for additional discovery regarding any criminal history that the victim had been involved with, but he made none of those moves.
Should we, in thinking about this, be aware of the entirely practical point that counsel had access to his client? Presumably, through access to his client, he could learn that his client was saying it was self-defense?
I think that is a relevant consideration, and I think it also points to another weakness on the claim on appeal, which is there's no allegation that the defendant was going to testify. If the defense was going to be changed from identification to self-defense, the defendant would have needed to point to some kind of evidence that he personally was in fear for his personal safety.
But that could be the adjutant evidence. That could be the evidence of the victim's reputation.
Yes, I agree, but adjutant evidence could cut both ways. Suddenly, the defendant's criminal history or reputation for violence could be introduced as well, and that opens the door potentially to the gang evidence that he claims he was trying to keep out, which he did, in fact, keep out in a motion in limine. I think under those circumstances...
If the motion in limine, I'm sorry to... But if the motion in limine said, I move in limine that there be no reference to my client's involvement with gangs, how could the prosecution think that right out of the box they could establish that the police officers were members of the gang unit?
I think it's a more attenuated reference because they explained that their duties weren't exclusively, they didn't know the defendant exclusively through his criminal history. And there was no testimony that the
motion in limine was allowed, right? I can take a look at it and I can
yes.
figure out what was asked?
As to the gang references to membership in a gang, that was allowed, and it is in the record. If there are no further questions, I will rest on my brief as to the third issue.
All right, well, let me say, I know we've got a first argument and a second argument here, and I hope both of you stick with appellate work because it's been a delight to read your briefs and to see your argument, and I hope we get to see both of you many, many times. Thank you both.
Thank you, Your Honor.
How are we doing? All right. Third case we lost because of illness of one of our attorneys, and we definitely appreciate when attorneys tell us that they're ill and don't come here and infect everyone. So we'll jump to what was the fourth case, number 23P328, John Doe 526712 versus the Sex Offender Registry Board. Counselor, whenever you're ready.
Good morning, Your Honors. May it please the court, Attorney Xiomara Hernandez for the plaintiff appellant John Doe. I'm here today requesting that this court lower my client's classification level from a level 3 to a level 1, or remand the case back to the board for another classification hearing. I'm sorry, I keep stepping on something. As you'll see, my first argument is that the hearing examiner erroneously found that my client raped his former girlfriend in 2020. If you see in the record, he was charged with it, but it was dismissed. His former girlfriend had actually submitted an affidavit, a signed affidavit, and notarized to the court indicating that he had fabricated the original allegations. And also there was no witnesses and there was no other evidence regarding this. Again, it was hearsay evidence that was unreliable. And so for these reasons, I would say that the hearing examiner erred by finding that my client actually did commit that crime in 2020.
When you say there was no other evidence that it had happened,
of the rape.
surely there was corroborative evidence from the police officer's observations of the victim and bruises and a black eye.
Yeah, so the corroboration was regarding the physical, something physical happened to her, somebody hit her. But in terms of the rape, there was no other evidence corroborating that it happened. And in fact, as you know, she submitted a notarized letter indicating that it didn't happen. So there's two documents in front of you. There's one, the police report, her saying that this happened, and then later on, a letter notarized.
Does her affidavit say, I was never physically assaulted, or just I was never raped?
It says that if you look at volume 2, page 128, he says the person's name did not rape her. So
He also says he did not assault me. It was consensual. I retained my injuries from falling down the stairs.
She does say that in there. And so the police report is hearsay. So we do know that the police report is hearsay. And if it's reliable hearsay, then the hearing examiner could adopt it and could find that my client did in fact rape his former girlfriend. I think the fact that there's a notarized letter submitted into evidence indicating that he is taking back all of that and that it did not in fact happen calls into question her reliability. So she's the reporter, and if she's not reliable, then the hearing examiner could not find that
So
what
a
she
signed
told.
notarized recantation as a matter of law disables the hearing examiner from relying on the police report and what's in it?
I'm sorry, say that again?
It sounds to me like your position is because there's a signed notarized recantation, the hearing examiner is disabled as a matter of law from relying upon the prior police report.
I wouldn't say it's a matter of law. I think under these circumstances, there's two documents again. There's the police report and then there's her notarized letter.
What about the affidavit? You've referred a few times to documents, but there's a sworn statement she made, correct?
No, I think what we have here is the police report, them
The 209A
summarizing.
affidavit, don't we?
Restraining order affidavit.
Oh,
is
the
what I'm
restraining order, yes. Yes, in it, he does say, and again, this was around the same time. It's like 3 days apart.
August 31st, I believe, a few days after,
Yeah,
correct?
a few days later. So it was just a few days apart.
So she wrote under the pains and penalties of perjury that he beat her and raped her.
Yes, yes. So again, there's multiple documents, and one says X and one says Y, totally different things. So that's what I'm saying, that it calls into question her reliability, because it is her who signed that notarized letter indicating that it didn't happen. So under these factors, under these facts, there wasn't sufficient for the hearing examiner to find that he in fact did that in 2020 to his former girlfriend. So because of that, I was, and also, as you know, the charges were dismissed.
Where do the burdens of proof lie at the hearing itself? I mean, I'm just thinking about this from the perspective of, he's a hearing examiner, right?
Yes.
He has evidence in front of him. He's opening up to say, okay, I'm gonna take evidence on what happened. He gets a police report from the board. He gets an affidavit. Is it Sorb's burden to prove that it happened?
Yes, it is Sorb's burden.
It's Sorb's burden to prove that it happened by a preponderance
Preponderance
of the evidence.
Yes. But I think as I indicated, there's just not sufficient here, even with that lower standard preponderance of the evidence, because again, there's multiple documents from the same person, so it does call into question her reliability. We could guess, and our guess may be a great guess, but I don't think it meets that burden of preponderance of the evidence. And also, my client was level 1 to begin with, and the reclass sought to classify him as a level 3, so that's a huge
And our
difference.
review is just for substantial evidence, right? It's
Yes.
not even like a clear error. It's just substantial. I don't know
Correct.
which one is higher, to be honest, but. Okay.
Correct. And so, I would assert that because of that error in finding that my client raped his former girlfriend in 2020, the hearing examiner went on to apply the only high-risk factor that he found in this case, which is factor 2, repetitive and compulsive. And then in addition to that, he added 3 other risk-elevating factors, which were factor 8, weapons and violence and infliction of physical harm, factor 19, which is another risk-elevating factor, which is the physical contact, and then factor 21, which is diverse victim type.
Well, if we knock out the rape, it definitely has to go back at least.
I'm sorry?
If we knock out the rape, it certainly has to go back. I mean, the rape finding is
I think,
central here.
Absolutely. I mean, I requested it for it to be lowered to level 1, but I think remanding it back to the hearing examiner, under these circumstances, I think is most definitely warranted. Another error the hearing examiner made was the application of risk mitigating factor 33, which is home situation and support system. The hearing examiner indicated that he gave this factor minimal weight instead of full or higher weight because of the 2 letters that were submitted didn't indicate that they were aware of his sex offending offenses. I would assert that if you read the plain language of the factor 33, the only instance where that would even come into play, whether it is important for the hearing examiner to know that the people supporting the offender knows about his specific offenses if they're going to give it greater mitigating weight to this risk mitigating factor. Here, that he gave it minimal. He didn't even give it threshold or full weight. But that being said, the letters, you could really infer that they did know about his sex offending behavior. Maybe not specifically, what happened, but they did know about it. His mother wrote in her letter that he hopes that her son's classification level does not switch to a level 2 because that would be a major setback. By level, you could infer that he's thinking about the classification level. So I would assert that he did in fact know that her son was involved in criminal behavior involving sexual assault. And then the letter from his friend was sent directly to my client's
What
SOAR
would tell
attorney.
us that they know or believe that he committed a rape? Now, I understand you want us to knock the rape out altogether, but if we do that, the whole thing's got to get redone. But assuming the rape stands, why would we assume that his mother and the friend would believe that he committed the rape and thus be able to support him and not reoffending in that way?
So I don't think the regulation indicates that the person has to know the exact, the exact things the offender committed, but just that he is a sexual offender. The language is the history. Hold on.
Sex offense history.
Sex offense history, yes.
Which I wouldn't think would be a yes/no thing.
I mean, he wasn't convicted of the rape, so would you consider that a sexual offense history? Probably not, if this, according to this. They did know that he was involved in activity that he was a sexual offender. So it looks to me like they did know that. The mother, again, referring to the levels, and then the friend actually sent the letter that he submitted directly to his SOAR attorney. So I think you could infer that he also knew. And so, the boards, they're supposed to find by clear and convincing evidence that my client poses a level 3 sex offender. And under these circumstances, I would submit that there's not clear and convincing evidence that he poses a high risk of reoffense because of the errors that I mentioned. But also, he only has 1 sex conviction on his record from 2017, which is 6 years ago. He will be on probation for 5 years, and the conditions of that probation is to remain alcohol and drug-free. to have mental health evaluation and treatment and sex offender treatment as well. And he did begin sex offender treatment. It was in the beginning in 2019, so at that point during the hearing, he had just started. But that's a requirement of his probation, is to continue with sex offender treatment. And as I indicated, he does have the love and support of his mother and a longtime friend. So for these reasons, I would ask that this court either lower my client's classification level or remand it back to the board for another hearing.
All right, thank you. It's always a pleasure. And speaking of always a pleasure, Counselor?
Thank you. If it pleases the court, David Chennai for the board. The rape allegation is central to this case. The board's position is that the hearing examiner really looked at the facts of it and determined by a preponderance of the evidence that the rape did occur. The hearing examiner looked at the fact that the woman gave 3 statements. The first day after the sex offense, she reported it to a police officer. The next day, she discussed it with a detective, and then 3 days later, she had the affidavit with the restraining order violation or request, and all of them were consistent, factually detailed, and so the board's position is that's sufficient under the circumstances for the hearing examiner to rely on it, on that evidence as proof that by a preponderance of the evidence he did commit that rape. And I think Doe 3177 is the central case on that right now. As for the factor 33, I would point out that the mother and longtime friend have been his support for a number of years, but it hasn't prevented him in 2018 from committing a domestic assault and battery, from committing a sex offense in 2017, from waving a pistol on a street, a loaded 9mm pistol in 2021. So obviously his support network, although they are supportive of him, aren't preventing him or helping him to avoid liability, of criminal liability. So I'm not sure how strong that support system is.
Let me suggest this to you, and you can tell me if I've got it wrong. But this isn't the first time I've seen this. The reg says the likelihood of reoffense is reduced when an offender is supported by family, friends, and acquaintances, period. And then there's greater mitigation consideration when they know about the sex offense history and they can support him. And so it would seem that this factor would apply, just not apply greater. And yet this is not the first time I've seen an examiner go to minimal, even though the regulation seems to say it reduces.
Well, again, I think you have to look at the application of the regulations in a common sense way. The regulation gives out the basics of what's required to establish support network. And again, this case, there's evidence that the support network isn't working. I think it was reasonable for the hearing examiner in a common sense approach to the application of it, not to just blankly say, okay, he gets threshold weight, even though he's committed these kind of offenses with the support network in place. And I think that's how you have to look at the application of the factors.
So here's the thing that I've seen before and that I find troubling. Okay? This determination, as Justice Ditkoff points out, depends on a finding that there was a rape. There's no criminal finding of a rape. In fact, the charges were completely dismissed, did not go forward, and the victim said it did not happen. And the only proof of it that's presented by Sorb, who has the burden of proof, is a police report. It seems to me, just sort of musing about how these things work or ought to work, that if you want to rely on an allegation that is unproved and recanted, maybe a police officer ought to show up at the probation at the Sorb hearing and say, "Yep, I was there. I saw the bruises. This is what they looked like. I talked to her," because otherwise, putting the hearing examiner in a pretty tough spot, aren't you?
I'm not doing it personally, but I know what you mean.
Well, but Mr. Chennai, you've represented the board for a while. So what's your reaction to that?
My reaction is that I don't think that's going to happen. First of all, I don't think the board's going to bring in police officers to testify at these hearings for events that occurred in the past. I think that they're relying on the case law, which the case law gives the hearing examiner the discretionary authority to determine whether or not a statement is reliable, and this court's analysis based on whether or not the hearing examiner made a clear error of law. And in this case, the board's position is it was reasonable for the hearing examiner, based on the evidence presented, to accept by a preponderance of the evidence that the rape occurred. And it cites in my brief the number of cases based on reliable hearsay for agency procedures, so especially SORD procedures. So I think that the issue is, if you find the hearing examiner made a clear error of law.
Well, no, abuse of discretion in his evaluation of the evidence, such as it was, which was a police report versus a recantation affidavit. Police report and, as Justice Smith points out, an affidavit, a 209 affidavit as well, which was signed.
So I think you have to decide whether the hearing examiner abused its discretion. And I think that, and that's why we have the system set up the way it is. It goes to Superior Court automatically, just about. I mean, all they have to do is file, and then they have a right to an appellate review of that. So if there has been an abuse of discretion by the hearing examiner, the idea is it's going to get picked up either in the Superior Court, which the Superior Court agreed with the hearing examiner, or with this court.
I can certainly imagine, without much difficulty, cases where someone is designated as a level 3 with respect to a recanted challenge that one might look at and say, Well,
also gotta look
take
at
a look at Commonwealth against Costa, decided by the Supreme Judicial Court a couple of years ago, where you had, allegations of serious rape that were allowed to revoke probation in that case. It troubles me, the context in which this gets decided. That's all. I'm just raising
I think
the
you also
question.
have to keep in mind the hearing examiner did point out that this isn't the first domestic incident with violence against this victim. So there's showing a pattern. And another thing to look at is the fact that he commits, while intoxicated, a 2017 sex offense against 2 stranger women. And this event happens right after he's classified as a level 2 sex offender. So it's like, if you look at it in that lens, it's like from 2017 and then the other intervening issues that are coming up, such as the gun waving on the street, in fact, a loaded gun. These issues are starting to look like that his life is somewhat out of control beginning in 2017. I mean, he had issues up to 2012, serious issues, but there seemed to be a lapse in there where he wasn't getting in trouble, and all of a sudden in 2017, it starts escalating again. But now there's a sexual component to it, beginning with that incident in the store in 2017. But again, I think the ultimate question is, you have to determine, did the hearing examiner abuse his discretionary authority in accepting this evidence as proof by a preponderance of the evidence that the rape did in fact occur?
All right, well, let me engage in my traditional complaint that it would have been really easy to get the transcript of the conviction and submit that to the examiner, though I know the conviction wasn't really driving the bus here, but...
And I don't drive that bus either, Your Honor.
But you know the bus driver.
You know the bus driver.
Well, thank you both. It's always a pleasure. We're going to take a break. It will be no longer than 15 minutes, and then we'll be back out here for the last 2 cases.
Thank you.
seated.
All right, we're back in session. I'll call the next case, number 23P 979, adoption of a child. I'll remind everyone that this case is impounded. We won't be using the name of the mother or the father or the child. We're not going to use the child's first name. We'll just say child, and the other child can be younger sibling or something like that, but no names, not even first names. And with that said, whenever you're ready, counsel.
Thank you, Your Honor. Good morning. May it please the Court. Deborah Dow for the mother. There were 3 reasons in this case that the judge terminated the mother's parental rights, the first being domestic violence, the second, missed visits, and the third was that mother relied too much on her relatives. Each reason is fundamentally flawed. I'm going to look first at the domestic violence. Excuse me. The judge found that the mother...
Would it be appropriate to add to your list her failure to engage in services?
Well, I think the judge looked at her inconsistency, but hopefully as I go through domestic violence, her groups, her individual therapy, I think that it will hopefully become a little bit more clear that she was in fact consistent with her services that she was asked to partake in. The judge found that the mother did not have meaningful insight into domestic violence and had only recently engaged in domestic violence services and was in what the judge referred to as violent relationships. But in fact, there really was no denial here. The mother told the social worker about the domestic violence incidents that did occur. The judge finds that the mother did not prioritize the child because she did not immediately remove the child the night the first domestic violence incident occurred in April of 2021. But mother did prioritize the child. She did what I assume we hope all parents would do. She bought herself some time until she could, the very next day, safely extricate
I think
her
we
child.
think that we'd want most parents to stay with the child, separate from the abuser, and not abandon the child, not in the legal sense, but leave the child to relatives while they stay with the abuser for a month or two?
And I understand where the judge was going with that, but I would suggest to this court that domestic violence is complicated. And it's not a one-size-fits-all type of situation.
How long did she stay with the abuser? This is MO, right?
This is MO.
MO. How long did she stay with MO after the event that caused her to send the child to the godmother?
Your Honor, I think, unfortunately, there's not straight evidence on that particular issue. It sounds like, from what evidence or what we can infer, that it was relatively soon. I would say maybe between 1 to 3 months at the most.
There was another event that precipitated it, right? That
There was.
precipitated a complete break between the two.
There was.
Okay.
There was. And after that point, she was able to work with her domestic violence provider, the alternative house, to obtain a restraining order, and that restraining order was actually in place still as of the time of trial and would have extended through trial to July of 2023. Excuse me. In addition to extricating the child, she was able to provide a caretaker affidavit and to ensure the child's continued care and safety with somebody that she knew and someone that she trusted. Mother's parental rights should not be terminated because it took her a bit longer than a day, a week, to extricate herself from that domestic violence.
Could I ask you a question? In your brief, you write on page 19, there was no evidence that the child witnessed the instance of domestic violence led to her removal. But I believe the judge made a factual finding crediting the child witnessing M.O. striking the mother. Is that incorrect, or how do you reconcile those two?
The mother testified that the child was in her room at the time of the only domestic violence incident, that she was in the household. The judge did make a finding that the child had witnessed mother being struck, I believe, and that the child, and crying, and she saw her mother crying.
So to say that there's no evidence that the child witnessed the incident, that's just inaccurate.
I'm not sure that it is accurate. I do think in the end that the judge made a finding
Okay.
that the child did witness. The social worker did testify that the child was not in any services for the abuse that the child witnesses, and that the child seemed to not have any impact from that. As I stated, there really is no perfect way for a domestic violence victim to extricate themselves from a situation. And in this case, the mother did extricate herself as quickly as she could, not fully understanding what those circumstances might have been that didn't make immediacy possible right away. The mother's engagement in domestic violence groups and individual therapy was not recent, despite what the judge found, nor was her understanding of domestic violence. The social worker testified that she was able to speak with the domestic violence group facilitator and had no concerns about, and that facilitator had no concerns about mother in the groups, and that mother understood the significance of the event that led to the removal of the child. The mother was able to articulate the impact of domestic violence. The judge acknowledged that mother identified the impact on her daughter, and
Because the child's childhood was messed up because she couldn't be with mother.
right.
Yeah, that's,
In addition to that,
do you think that that is a compelling or even passable description of the possible impact of domestic violence on the child?
well, I do if you add in what else she said, which the judge did not make as part of his findings. What he left out was that, from mother's testimony, I think was actually even more important. Mother testified that it didn't matter if the child was in her room during the April 2021 incident, because she was in that environment and she can be traumatized. So I do think with that additional information that mother testified to, that she does have an understanding of
Was
the
that
impact.
was that basically an answer to the same question that we've seen the excerpts from?
It is. It's the same grouping of testimony. And I would suggest to Your Honor that these
I didn't
statements,
see that in the briefs. I'll read it in the transcript.
I would suggest to the court that the statements that mother made are correct.
Well,
There's nothing
it's kind of
incorrect.
problematic because you were just talking about how laudable it was that the mother separated the child from her to protect him from the domestic violence, and the mother's takeaway seems to be that she shouldn't have done that the impact is the separation. Well, where does that leave us?
Well, I'm not sure that was her understanding. I'm not sure she was testifying to that. The impact was that the child could be traumatized. The impact was that she should never have been in that environment. And I think that information is compelling. And perhaps they weren't said in the, sophisticated manner that the judge would have liked, or that maybe he was looking for, or maybe there was a clinically more appropriate way to say it, but we don't hold parents to that standard, and nor should we. The mother was in domestic violence groups from June of 2020 until August or September of 2022, which is a significant period of time. And then there was testimony that she resumed again about a month and a half or so before trial.
Did she regularly attend the groups?
She testified that she did, and then the social worker also testified that mother had been attending weekly when she had called the facilitator. So as far as later on, I don't know that there's evidence as to that as she got closer to giving birth to her second child. But at least for a period of time, the testimony was that she was attending weekly. She also engaged in individual therapy. Mother testified from February 2022 until the therapist left in approximately October 2022. And this therapist was clear that mother was making progress, working on her treatment goals, including learning to care for herself, her child, noticing red flags in relationships, speaking for herself.
Is this an argument that the judge's findings are clearly erroneous?
In total, because the focus...
In total, that seems kind of odd to me.
There-
You mean the conclusion drawn from the findings in total was clear error, but the findings themselves are accurate?
I'm not suggesting the findings were accurate, particularly with respect to the domestic violence. I think going through these particular findings, I think it was clear that there were error in the findings. This case really is...
So which findings are in error?
The findings with respect to the fact that she did not understand the impact of domestic violence, that she did not engage in services to address domestic violence, and I think those were really the bulk of what led him to the conclusions that he came to as far as mother's inability to extricate herself and to prioritize. She did, as I said, the fact that she didn't immediately remove the child the night of, but the next day. Excuse me.
Can we talk about, because your time is waning, what I take away from this, more than domestic violence even, is the mother did not show that she was interested in parenting this child. And, there's a question, sort of an overarching question, as to whether that's enough to terminate parental rights. But what about the findings about not visiting regularly with the child? For example, there is how long, 10 months that so she has the issue with MO, she transfers the child to the godparents. I think it's 10 months that the child is with the godparents, maybe prior to trial. I'm not sure if I got this right. But there's a finding that she visited infrequently when the child was with the godparents. Is that clear error?
I think you mean prior to the child's removal from the mother? Is that what you're referring to?
Well, I'm talking about when the child, so I'm not sure I've got removal in my timeline.
So the child did spend significant amount of time with the godparents.
There's an event which causes her to take the child to the godparents again. The child had spent a lot of time with godparents early on at what appears to be everyone's agreement, right?
Right. That's correct.
And then there's an event which triggers her sending the child to the godparents. I have a date in my head of April 2021. I'm not sure that's right. And then the child is with them for an extended period of time, and the judge makes a finding that mom doesn't visit.
So mom was visiting. There was a period of time post-removal, post-April 2021, when mom did struggle to visit, and she testified to that. She was working at Federal Express overnight and had a difficult time making the visits during the daytime. But once she changed jobs, once that job was over, she started to visit, and she visited regularly. She visited 3 out of 4 weeks per month. And during those visits, there certainly was no indication that she wasn't caring for the child, that she wasn't capable of caring for the child, or that the child didn't want to visit. I think all that evidence was certainly in.
That's the problem we have in this case, though. 3 out of 4 visits, 1 out of 2 trial days, eventually leaving the abusive boyfriend, but not immediately. I mean, it certainly shows a lot of inconsistency, but really the question is that enough to terminate that kind of inconsistency. So give you an opportunity to tell us that it's not.
So it is not. It is not enough to terminate. And again, I think that this goes to the issue of grievous shortcomings. Is this enough to suggest that her inconsistency, 3 out of 4 visits, but those visits going well, the department even conceding a bond in this case, that was enough to terminate her parental rights, given all of the other issues that, you know, are present in this case. The department cites to numerous cases, all of which stand for grievous shortcomings. The fact that the parents were behaving in an egregious manner in those cases, that's not this case.
Well, the bond is, I'm sorry.
No, go ahead.
The bond itself is a double-edged sword because the child cries when she doesn't show up, and she doesn't show up with a little bit of regularity, right? Isn't that neglect in itself?
But when mom does show up,
Well, but I was asking about when she doesn't, and the child cries, the child's upset. Mom is neglecting me.
well, I wouldn't suggest that mom is neglectful, but I would say that in those circumstances, mom, and we don't know, the evidence just wasn't there, mom does not participate fully in the visits. But again, it certainly does not suggest that there was, you know, not a bond or that mother could not parent this child. Mother could parent this child, and she had parented this child. And I think that, you know, one of the other indicia was that the fact that these godparents, right when this case started, went to probate court to try to get custody of this child, and were not able to do that in the probate court. So the inconsistency that this judge saw was not something that was relevant for purposes of custody in the probate court.
I'd like to ask you one question about the recusal issue. I couldn't really figure out what the judge presided over with the other sibling. There was no temporary custody hearing, hadn't gone to trial, so what was the judge?
The judge presided over what we colloquially refer to as a third-party placement hearing in the other, with respect to the other child, the child that was born in September of 2022.
And what is that? I don't know what that is.
So it's akin to a temporary custody hearing. So as part and parcel of the temporary custody hearing, parents can offer a custodian.
Oh, so the question of where the child would go.
Correct.
Not as mother stipulating to unfitness, at least at the time, but litigating where. I get it.
Right, right. And I don't know, the evidence wasn't there as to whether or not mother stipulated to unfitness.
Well, was there evidence in front of the judge even as to what it was that, I can't remember if this is a he or she, might have learned in that hearing?
Well, it would have had to have been. There's no doubt that it would have.
Well, no. That's, you want the judge to recuse. You recuse on the basis that there's some sort of impropriety associated with sitting on the second one. If we don't know what the judge learned in the first one, how could we make a judgment as to recusal?
Well, I think the tenor of the case was set out in the 51A that was entered into evidence. So
With respect to the second child?
with respect to the second child.
I have one other, I'm sorry.
No, go ahead.
I have one question because we're way over. Can you help me with something that bothers me, which is just the dynamics here? Why is DCF asking to terminate her parental rights when the child is in a kinship placement?
Right, and obviously that would be mother's argument, that this really was a case for permanent custody. Mother was doing some services, the child was in a...
But can you help me with the dynamics? Does the record indicate what the dynamics are such that DCF feels that it needs to terminate her rights even though the child is with a godmother?
I can't, Your Honor. I don't know that there's any evidence with respect to that.
Okay, thank you.
At all.
All right, thank you very much.
Thank you.
Excuse me. All right, my understanding is that the department will take 10 minutes?
That's right, Your Honor.
All right, whenever you're ready.
May it please the Court. Arjun Jakumar for the Department of Children and Families. The trial court found mother unfit to parent child because of a clear and long-standing pattern of inconsistency. As the trial court put it, inconsistency in parenting, inconsistency in services, inconsistency in visiting, inconsistency in engaging with the department. That's the conclusion of all three. And the trial court found that that pattern of inconsistency had an impact on the child. It demonstrated that mother had not made the child a priority, and that that pattern was likely to continue into the future. That conclusion was supported by clear and convincing evidence, and the trial court's determination is entitled to this court's deference.
Yeah, it would be, except the standard is grievous shortcomings.
That's true, Your Honor.
What's the evidence of grievous shortcomings? That she's inconsistent? That she placed the child with someone who can take care of the child, and as far as we know, is taking care of the child just perfectly fine?
Your Honor, I think that the evidence of grievous shortcomings in this case is the pattern of behavior and the consistent theme of mother's relationship with this child throughout her entire life, since well before department involvement. And that is a continued shortcoming in terms of making the child's interests and needs her priority. And this goes back to before DCF involvement. I'd say the first example of this is that mother was only periodically the child's primary caregiver for the first years of her life. The trial court found...
I mean, in the old days, you know, parents sent their kids off to live with kin. They sent their kids off to boarding schools. We didn't say we're going to terminate their parental rights because we didn't like the way they were raising their children. And so I'm trying to draw a connection to grievous shortcomings here. Usually we see evidence of neglect or evidence of harm.
Yes, Your Honor. And I would say that, again, this is the first incident of of a pattern of behavior that has persisted throughout the child's life. And, for example, you know, Your Honor asked about harm. The second major incident, I would say, would be the April 2021 incident of domestic violence in the home. And at that point, as the trial court found, as Your Honors were questioning about, you know, mother had a choice as to what to do with the child's placement. And the trial court found that she prioritized her relationship with her abuser over her relationship with her child.
Boy, I'll
She
tell
sent
you,
the child
I've
away.
sat through really good discussions and seminars about domestic violence, and surely it's not uncommon for someone not to extricate themselves immediately from a domestic violence circumstance.
No, Your Honor. That's...
It doesn't make them an unfit parent if what they do is they get the child out of that immediately, which is what she did. In fact, in some of the things I've sat through, it's suggested that's exactly what ought to happen.
Your Honor, it is the case that that is an interpretation that one could make, but the trial court's determination, which is evidenced, I think, by the fact that not only did she not immediately terminate her relationship with her abuser, it continued for a matter of months, at least to the court's question, I think, earlier, at least until the court-appointed investigator's report in July of 2021. So,
how long is that? Help me. How long?
So from April through July, 3 months, 4 months at least. And I do not know, and I agree with Ms. Dow that I do not know from the record exactly how long that relationship with MO continued. But it certainly continued for a period of time. There was an additional incident of domestic violence in the home. There was the incident of her showing up at his court date with, you know. So certainly, the case law is clear. I think this is Lorna, that a parent's decision to maintain a relationship with an abuser is an important factor for the court to consider. So that, I think, would be the second factor that I would understand.
But aren't most of those cases about continuing a relationship with the abuser while the child is present and is going to witness and be subjected to the domestic violence? I mean, that's the context in which I recall those cases being written.
As a general principle, Your Honor, that has been the case in a number of the prior cases, but the maintenance of a relationship with an abuser, especially given the context of these circumstances in which the trial court made a determination that this was reflective of mother's priorities as to her relationship and her relationship with her child. And again, I'd say this is the second in 4 or 5 different factors in a pattern of continuing to prioritize other relationships, other issues in her life than her child. I think that that's reflected again in her inconsistent engagement with services and with visitation. The action plan set forth by the department, respectfully, Your Honor, was not extremely onerous. It required engagement with services and it required weekly visits, 3 of which I think per month at the outset, this was during COVID, were via Zoom. And the testimony of the ongoing social worker was that she missed, at minimum, 1 visit per month. At the time of the investigator's report in July 2021, she'd missed 3 in a row. So, again, Your Honor, that is, simply a matter of being...
Why does the department want to terminate her rights when it's a kinship placement? I mean, it seems to me I can understand these arguments in terms of her unfitness at the time. I can understand them. And I guess she stipulated at the temporary hearing, right?
That's right, Your Honor.
But why insist? Because termination requires a showing that it's likely to continue forever, basically, or for the indefinite future, right? That's the language of the case law.
Yes, Your Honor.
She's 25 years old when these events occur. Is that right? Had the child when she was 20?
That's right, Your Honor.
So why terminate? What am I missing?
I think that the basis for termination is, again, a longstanding pattern. Not to repeat myself, but this was someone with whom the department had worked with at the time of trial for 2.5 years. And this is the first page, the transcript, the first day of the transcript, page 90. The testimony of the ongoing social worker, who was the social worker throughout that time, is, in these 2.5 years, she hasn't made progress in any area of concern to the department. I understand that this is still a parent who is young, who has, for whom growth is possible, but I think that the best evidence available to the trial court was that this is a pattern that has persisted for 6 years throughout this child's life, and there were no indicia before the trial court that it was going to change. And so that, I think, is the basis for why the department sought termination, and to put the child in a placement, in a permanent placement, and to give parental rights to a family and to a home where she had the stable and consistent home that she needed. And I think that was the basis of the trial court's determination that, based on the 6-year pattern, based on the lack of engagement in services and ability to benefit from those services, which I think is also critical, that the department witnessed, that the trial court witnessed.
There's no termination of parental rights. What happens? The care and protection case just stays open and the department has to continue to provide services?
I think that's right, Your Honor, but if there's no termination of parental rights, I think that leaves open indefinitely the question of where the child will ultimately be placed, and whether it's with the adult.
Is there any evidence that anybody cared? I mean, mom gave the child to the godmother for years.
Yes, Your Honor, but I'd note, mom gave the child to the godmother and her wife for years, and then the department first became involved because at one point she picked up her child from the caregivers, which she had a right to do, and went to a hotel, and there were some concerns about supervision at that hotel. So, Your Honor, I think to the extent that the child's placement and the rights of the pre-adoptive family, the adoptive family, are not adjudicated, that leaves open indefinitely the question of who will be taking care of the child, who has the right to assume care over the child, and whether that placement is in the child's best interest. Ultimately, Your Honor, I think that is why the department's goal changed, because it was initially reunification for a year, after removal. I think that is why in May of 2022, the department's goal changed to adoption, because there was a determination in the department's judgment, and I think this is what the trial court found, that long-term, the child's best interests are served by having the placement resolved and allowing, as you said, this is a kinship placement, so to the extent that mother wants to remain involved in the child's life, that should be something she can work out with the adoptive family. But that termination of parental rights was in the child's best interest because those parental rights properly belong with the adoptive family. I assume your honors have more questions. I know I'm out of time, so.
So often in these cases, when the department alleges areas of unfitness or a court finds a parent to be unfit, there's an attempt or a connection between those allegations or findings and the impact, causal on the minor, say. For instance, we had a case recently, or hypothetical, I'll give you, where a parent was alleged to have been neglectful and wasn't following through department plans and wasn't involved, and a 6-year-old hadn't been toilet trained yet. So things of that nature, we see the impact. We see how the best interest of the child may be affected by the parent's shortcomings or alleged shortcomings. And I'll ask minor's counsel in a moment, but what is your perspective on how this minor has fared in light of what the department would call grievous shortcomings of the mother?
Yes. That's a great question, Your Honor. I would point out two things. First of all, the case law is clear. You know, there are cases such as Catherine, for example, that demonstrate that neither the department nor the trial court has to wait for disaster to strike, which I think, to answer your question more directly, it has not in this case. However, I would not concede, because I don't think it's true, that the child has not suffered harm from having lived in mother's home. I think that the trial court found that the child had witnessed domestic violence in that home, and Vaughn and a long line of cases demonstrate that that has a particularly grievous harm on a child. I would also state that mother's inconsistency in visitation has had an impact on the child. I think one of your honors observed previously that when mother would not show up for a visit, the child would become visibly upset. She would cry, that it was because she had a relationship and because she had expectations, reasonable expectations of emotional and physical availability that were not being met. I think that is another aspect of mother's parenting that has had an impact on the child.
Child in therapy?
Is the child in therapy? Yeah. At the time of trial, not to my knowledge, Your Honor. I don't know if that has changed, and minor's counsel can
As you
correct
say, we don't have to wait for disaster to strike.
Yes, that's
but on
correct.
the other hand, this is not the easiest of these that we've seen. Let's put it that way. The fact that the child can be harmed because mom is not paying enough attention to the child is, of course, true. But it would not distinguish this child from many, many other children.
Your Honor, I appreciate that, and I would state again that the trial court, I think, carefully considered the evidence and made a determination that is entitled to deference. But beyond that, I would say that the role of both the department and the trial court in these cases, and the case law is consistent with this, is not simply remedial. Nor should it be. I think it would be a disservice to the children of the Commonwealth if it were. It has to, at some level, be preventative. Now, I understand that presents a line-drawing issue for this court, but I would stand by the trial court's determination that in this case, it's on the right side, or the just side of the line.
Very well put, counsel.
All right, thank you, counsel. They didn't give you an easy one, but I hope you'll stick with this kind of work. We appreciate having you here.
I appreciate being here, Your Honor. Thank you.
We'll hear for counsel from the child.
Good morning. May it please the court, Roberta Driscoll-Weiss on behalf of the subject child. I will admit that I'm not as troubled by the court's decision as your honors appear to be, and I'll tell you why. prior to August of 2019, my client was placed voluntarily by her mother with her godparents. And in August of 2019, mother executed a caregiver affidavit giving the godparents care of the child. And in June of 2020, mother revoked that caregiver authorization, which left the godparents with no recourse to stop her. So mother took the child, went to a hotel room with her own mother, who she herself acknowledges has had significant substance abuse issues in the past. The family went and stayed in the hotel room for a period of time, and sometime subsequent to that, mother allowed M.O. into her home upon his release from jail. While he was on an ankle monitor, she allowed him into the home with her child. She testified to having no idea what the ankle monitor was, what was the cause of his arrest, what the charge had been. But she did acknowledge at some point that she was aware that he was dealing marijuana out of her home, marijuana that his mother would bring to him so that he could then sell it from the home that she shared with her daughter. In April of 2021, M.O. physically assaulted mother, and we've talked at length today about how mother chose to remove her child from the home rather than choosing to remove M.O. from the home and maintain custody of her child. Mother was subsequently assaulted again by M.O., leading to M.O.'s arrest and her obtaining a restraining order against him. When questioned by DCF about whether or not the relationship was at that point over, mother was equivocal, yet appeared at a visit subsequent to his arrest with a diamond necklace with his name on it that she was wearing. So there was some indication that perhaps that relationship was still ongoing. This trial began, the trial of this particular child began in March of 2023, but 3 months earlier, mother was assaulted by a subsequent boyfriend, leading to the removal of their child. So this is not a situation where mom did the best she could do after an incident of domestic violence.
The evidence on the second one, was that in at the hearing? It wasn't, right? Because it post-dated the trial?
No, it predated the trial, Your Honor.
Did that evidence go in, the evidence with respect to the domestic violence on with respect to the second father?
It did, Your Honor.
What did mom do with the second child?
So this formed the basis of the recusal motion. So DCF filed a care and protection petition with respect to the second child. That was the basis for mother's request.
So mom did not get rid of the second child. Get rid of is a terrible word. I'm sorry. Mom retained the second child in the home with the domestic abuser after notifying the police that the domestic violence had occurred?
No, my understanding from the record is that the 51A was filed as a result in December of 2022 as a result of the domestic violence. The care and protection petition was initiated. As you've heard, there was a third-party custody hearing, which this particular judge presided over, although had no recollection of the specific facts of the case. And the record reflects that the child was then placed in the custody of that father's mother. So at the time of this trial, mother had not regained care or custody of that child. That child was placed with his or her paternal
question
grandmother.
went to what the record shows with respect to what mom did after she was assaulted. As I understand it, she notified the police, right?
Mm-hmm.
And what did she do with respect to the child at that time? Did the child and the child's father remain in her home?
My understanding of the record is that when the police were contacted with respect to that December 2022 domestic violence incident with the, I believe his DM or his
DM,
initials, that DCF at that point became involved, filed the care and protection petition with respect to that child, and pursuant to a third-party custody hearing, that child was placed with the paternal grandmother. So I do not believe that mother retained care of that child after that incident of domestic violence. Your Honor's asked...
What does the record show with respect to what mom's position was as to what should happen to the child after the second incident of domestic violence?
I believe, and I will admit that I could be wrong, I believe that the mother assented to the placement of the child with the paternal grandmother, but I'm not entirely sure. But I think the important thing to note here is that in April of 2021, my client was removed from mother's care because of an incident of domestic violence. In December of 2022, mother lost custody of another child as a result of an incident of domestic violence with a different partner. And so I think the issue of whether mother or not was engaging in domestic violence services or therapeutic services or parent aid services, what we really need to look at is, did she benefit from any of those services? And I would suggest to your honors that 3 months before this trial began, mother lost custody of another child due to domestic violence.
Can we consider that? Can a judge base a custody decision on a custody decision in a different case, especially when it was stipulated to?
I think what the judge had to do was consider whether or not mother had made adequate progress as a result of services. There's case law that, participation in services isn't enough. One must benefit from those services. And I think that the judge credibly found that she didn't. And I think it's in conclusion of law number 34, he said, history is the best predictor of the future. And
Well, so let me try it this way. I mean, I see this factual finding 25, which says there was an incident involving alleged domestic violence between mother and this father that resulted in a 51A report being filed, but the 51A report isn't in substantively. And then says, mother testified that once the incident occurred, the relationship ended. And I don't remember mother testifying that there was to the actual incident happening. What's our evidence on this that's admissible to us?
I believe it was the 51B investigation, Your Honor. And again, I could be wrong, but I believe the 51B investigation was admitted in evidence in this case.
So I don't see a 51B that's that late. The last 51B I see is Exhibit 7, May 2021. Am I missing something?
No, I'm sure you're not. I'm sure I'm recalling incorrectly. If it possibly was the testimony of the social worker, I do know that that the judge made a number of findings with respect to that incident of domestic violence, one of which was that mother denied that there had been an incident of domestic violence with DM. That's fine.
She didn't deny there was an incident, apparently. She denied that it was domestic violence. I just read the findings.
Respectfully, I'm not sure I understand the distinction between an incident and an incident of domestic violence.
Because it could be yelling and mother doesn't think that's domestic violence.
And I think that...
It could be name calling. It could be all kinds of things. She testified that the relationship ended after the incident. That's the finding of the judge.
And I think that goes to my earlier point, Your Honor, which was that the evidence was clear that mom had not made the appropriate or necessary amount of progress. Truly, there is a factual difference between a physical assault and a verbal altercation, but each of those things is harmful when they occur in the presence of a child.
We're going to take children away now because the parents engage in yelling at each other.
It immediately causes the termination of the romantic relationship.
Well, and I think with respect to the questions earlier about whether or not this case warranted the termination of mother's parental rights, I think what we have to look at is also the child's need for permanence. I'm not sure that there would have been another alternative here that could not present, an unsure future for this child when mother had given a caretaker affidavit to the foster parents previously. She had revoked it. And how would that?
As is her right as the biological mother, and not just a right, a fundamental right. I think I understand. I understand your argument, and I understand the department's position.
In that case,
you started this by saying you don't have as much difficulty with this as we do, and that's part of the reason I think that the questions have been pointed.
And the reason for that is because not only does mother have a fundamental right to raise her child, but the child has a fundamental right to stability. And I think the termination of mother's rights in this case is the only possible path to stability for my client, which she has achieved, or which she has been given in the current placement with the foster parents. I would think the court would have been very concerned about the lack of stability had the outcome been anything less than termination of mother's parental rights, because there would have been no mechanism by which my client would be maintained in a stable home for the foreseeable future.
I'll ask you the same question that I asked your colleague. If parental rights are not terminated, then the process that then happens is that the care and protection would stay open and DCF would remain involved because they're the party then with custody?
So under 11926, the court could have granted permanent custody to DCF and off-listed the case, which is a manner of saying that the case would be in an inactive status. It would then it would be incumbent upon mother then to seek a right of review under 11926 showing a change in circumstances, but similarly, DCF could seek right of review and move to terminate mother's parental rights if they believed that appropriate progress had not been made. But I would also point out that the juvenile court rules require that there to be some level of permanence for children within 18 months of the filing of the petition. And for a 6-year-old child, I would argue that, a lengthy period of instability could not be said to be in her best interests. And with that, if there are no further questions, I would rest on my brief.
All right.
Thank you very much.
Thank you. Whatever we do, this child is lucky to have the godparents in her life, and we recognize that. I think everyone does. Thank you very much. This is a tough case, and it's been really well argued and briefed in front of us, and we're very grateful. All right, we'll move to our last case, 23P1206. Whenever you're ready, Counselor.
Thank you, Your Honors. May it please the Court. Kelly Cusack on behalf of the appellant defendant. Given the privacy issues in this case, I will refer to my client as the defendant and continue to use the pseudonym for the neighbor plaintiff, Christopher. First, while I know the court has read the brief and the appendix, I think it's important for me to highlight some of this contentious relationship that led to this breakdown between these two neighbor households and eventually...
Why is that important?
I think it's important because my client, the defendant, had this mounting frustration over the lack of parental intervention with Christopher, that there was no communication or parental discipline or intervention preventing him from climbing on top of the ladders on the play structure and yelling to her and having these.
You seem like you did in front of Judge Hinkle to want to litigate how good these parents are, where as far as I can tell, the only thing before us is whether there is a continued need for this order.
I'm not trying to litigate whether these are good or bad parents. I'm just trying to give you a context as to the words that were communicated and the actions taken on behalf of the defendant, so that the court can then take that context in evaluating whether there was a continuing need, whether there were 3 specific acts that met the definition of harassment.
Why is that in front of us?
I would suggest that there is case law that I had provided to the court that allows the court to review those 3 independent acts.
Sure, if there had been an appeal of that order, but this is just an extension after it had already been a first party. And I know you know this because you cited Danny D. and Jasmine Y. In your opinion, so I don't see how we get to evaluate the unappealed order. That's exactly what Jasmine Y. says we don't do.
I think here the court did actually relitigate this. I think the court did consider it. I think Judge Hinkle continually.
How do we know that?
She repeatedly said, and she wasn't, over and over again.
She did say she's granted leeway, that she did provide, that she allowed there to be additional opening of the testimony. There was testimony permitted from my client's sister, who was present during the May 2020 incident. There was testimony from my client and the defendant about both of the incidents and the photographs and police reports that were introduced that weren't part of the initial.
The standard at a one-year hearing is not that we redo the prior hearing. The standard is whether there is still necessary to have an order in effect to protect the plaintiff from further abuse. Counsel, I just remind you, this order has been in effect for a year, so the question now is what is necessary to keep the order in effect to protect the plaintiff from abuse? The case law says the opposite, frankly, that you don't relitigate the basis for the order.
And I would suggest that here there wasn't a continuing need, and I think that in order to address the continuing need, there needs.
Have you just pivoted from the argument that you made a few moments ago where you suggested to us that the judge did in fact allow a re-argument of the 3 to the real standard is whether there's a demonstrated continuing need?
I'm not conceding that that this court can't evaluate the 3 separate incidents, because I do think that the court, while she continued to say that during both of the hearings that were interrupted, we had 2 hearings, one that was interrupted and continued, there was this opening of evidence. And so I think this court can now review that there was additional evidence that was introduced in the hearing about the 3 particular incidents, and that was going towards the indication of the continuing need and the evaluation of all 3 separate acts. So I would suggest that this court does have the authority to do that because the trial court opened the door.
Did the judge ever indicate she thought that she was reopening whether or not she should have granted the order in the first place? I don't think she did, right?
I don't think it was specifically stated in that way, but I think the actions of the court by allowing additional evidence and then reiterating her evaluation in her findings, she does address each of the 3 specific acts. And I think, therefore, while we're appealing the extension of the order.
But that would go to a conclusion about continuing need just as much as it could go to a conclusion about whether the order should have entered in the first place, right?
Then I think
new evidence that indicates whether or not that there was a continuing need.
I think if this court is concerned about that, the remedy here would be a remand to determine whether or not that's what the court's intention was in terms of whether we were having.
Well, let me put it this way. If Judge Hinkle allowed you to relitigate the prior order, that was an error, right? Correct. Reversible error. So I don't see why we'd remand to ask her whether she committed an error that we would just have to reverse. The only thing she could do under Jasmine Y was determine whether there was a continuing need.
And I think what I'm suggesting here is that she did open the door and allow for this litigation about the 3 specific.
In which case she shouldn't have done that, but it's harmless because she didn't reverse the prior one, right?
Well, I don't think that it's harmless as it respect to my client, the defendant, who has an invested interest or an ongoing interest about even after an expiration of such an order or even the issuance of such an order.
Can I ask you that? Yeah, what's happened to the order? Is it gone?
It was continued to December 6th, which was the 18th birthday of Christopher, and it was again continued until March and then was terminated at that point.
March of 2023, 2024?
March of 2024. So just recently, the order was terminated.
It expired?
All parties were present at the hearing, and the plaintiff, the mother of Christopher, did not ask that it be extended. So the parties were in agreement, and it was terminated at that time. Going to the issue of, I was just addressing about the mootness here, certainly there's an ongoing interest, even after the expiration of the order. Essentially that this remains in a statewide domestic violence database and can never be removed. It has a long-lasting harm for someone positioned as the defendant.
But even if we vacated the extension, there would still be the original order after notice, which would stay in the database, right?
And I guess this is a question raised about whether this was relitigating the underlying order itself or if it was the continuing need. And I think that if this court were to address those arguments about the three specific acts, then I think it would vacate the order itself, the original order.
How can we do that? How can we review an order that wasn't appealed?
Again,
Even if you could relitigate, I don't see how we could reverse the original notice after hearing.
It's not something that I had considered, and certainly something I'm happy to address in a post-argument letter. I would suggest that here, even the extension of the order in terms of the continuing need, and I'm not necessarily conceding that we weren't able to relitigate the three specific acts, that there wasn't a continuing need at the time back in May of 2023 when the defendant appeared with counsel at this point and was able to provide, well, both in May and June of 2023. And I think there were three specific events the judge relied upon for the issuance and for the continued need. She reiterated the event in May of 2020, November of 2021, and April of 2022 in respect to the video.
All right, so why isn't there a continued need when in October of 2022, she, by her own admission, goes to this child who she's been ordered not to contact and tells him to shut the fuck up?
I would suggest there that this isn't this is not the same type of the language used. I think that the defendant's perspective and the defendant's testimony was that while it was not directed at, it was directed at Christopher, it wasn't said directly to him, and it was part of this ongoing issue with Christopher having access on the ladders, yelling down to the workers who had been working at her home. I think the order itself, this particular incident happened in October of 2023, and we're talking about another 6 months after that, or 2022, I'm sorry. And 6 months later, in May of 2023, was when we had the hearing about the continued need. So there was no intervening acts or events, incidents, or contact between the parties from October of 2022 until the hearing in May of 2023. And I think it's clearly documented in the record and the appendix that there wasn't any. And part of that was the defendant retaining counsel and having a better understanding of what were her obligations at the time when the original order had issued. So putting the one event aside, the only the argument I think that the court would have the most questions about was what the issue I've raised regarding whether it was constitutionally protected speech in the language that she had used against the plaintiff, the minor plaintiff. I would suggest
preliminarily, you sort of in passing mention in your brief that you think that some of this was videotaped, correct?
Correct.
And apparently played at the first hearing?
Yes.
Where she was representing herself?
That's correct.
Is there any indication there was an objection to the use of that videotape?
I don't know that there was an objection. It was unclear to me from the transcript and the record whether or not the defendant at the time, who was proceeding pro se, actually had access and had seen the entirety of the video. It certainly wasn't marked as an exhibit or introduced in the traditional sense, and I certainly can understand that these hearings happen in very busy district courts, particularly when you're having two pro se plaintiffs and defendants representing themselves, that it wasn't necessarily introduced in that way. So I don't think there's an outright objection. I'm not sure, other than it being referenced on the record and indicated in the statements in the affidavit filed by the plaintiff's mother on his behalf, it wasn't fully marked as an exhibit or introduced at the first hearing.
Is it your position that that evidence should have been ignored by the judge because it's in violation of the wiretap statute? Is that your position?
I don't know that that was the position that I took. I think the issue was about whether it was properly introduced at the time, and understanding the dynamics of someone looking at a cell phone. It was very clear that the defendant was unaware that she was being recorded, and I think it's...
How is that clear? I thought the mother testified that she was holding it in her hand.
Without recreating this particular issue, you can see from the photographs that are attached to the appendix, there was a privacy fence at that point installed both on each side that was approximately 6 feet high, and that the plaintiff's mother was more on her porch. My memory of the record was that she was on her porch while Christopher was in the yard, and that the defendant was on the other side of the fence. So even if someone from a porch is holding a phone, in front of them, most people, I think we can agree, we all kind of carry our phones on us. They have a wealth of information in terms of having contact in our emails and everything. So I don't think someone would interpret someone holding a phone as being recorded, particularly where we're talking about a significant distance away, which I think is clear within the photographs that were attached to the appendix or introduced at the May and the June of 2023 hearing. If the court were to find that that was not properly preserved or introduced, I think then this court could find that there was not three specific acts. The three specific acts that were relied upon by the court were the May 2020 incident, the November 2021, and the April 2022, which was the video.
Before you run out of time, Appellate Rule 3 requires a notice of appeal in a civil case to describe the orders being appealed. And I'm looking at your notice of appeal, and it doesn't seem to do that. I'd like your best argument that it's an effective notice of appeal.
I would suggest to the court that the notice, it references the docket number for the restraining order, or the harassment prevention order. That's the only thing that's inside of there that would be appealed. And so I would suggest that that is sufficient, and that the three acts were specifically outlined in the actual order itself and enumerated by the court. If you look at the handwritten enumerations, pointing out 1, 2, and 3, along with some property damage, which wouldn't have been directed particularly at Christopher. There was an issue over the property line there where the allegation was the defendant pushed over a fence. So I think the appeal itself is sufficient based on the harassment prevention order itself and the enumerations as made by the trial court.
I know you want to talk about fighting words, so why don't we talk about fighting words? So why does it matter that the child may not have been able to fully understand what was being referenced if someone who is a caretaker of the child could understand those things?
Because in the context of a harassment prevention order, that it has to be aimed at a specific person, and it's that specific person that then has to be able to be...
But why does the First Amendment protection depend on whether the person you're specifically directing at it would be cause to fight. I mean, if for instance, someone used the N-word on a black person in front of other black people, even if that black person happened to be deaf, I wouldn't think the First Amendment would protect that because it would be likely to cause a violent reaction.
And I disagree with the court. I think that it has to be a direct personal insult that's inherently likely to provoke violence.
Right,
and that
but
needs to be from...
Stop. That's, I think, what recent cases say and pretty close to what Chaplinsky says. Reasonably likely to provoke violence. It doesn't say reasonably likely to provoke violence by the person you were directing it at. Reasonably likely to provoke violence because at the point at which you using your speech in a way that's going to cause a violent reaction, it loses its protection, right? That's what the gist of the First Amendment law is.
And I would agree that that's the standard, and I think I cite in my brief a Fourth Circuit case out of the Court of Appeals, the United States Court of Appeals, that address a racial epithet that was spoken to an employee of someone who, the defendant there, trying to purchase some boots and other military uniform. And even there, they said that the racial epithet, the issue was that there wasn't enough on the record to show what the violent reaction or what the indication would have been.
I'm not sure that Fourth Circuit case would be followed by our Supreme Judicial Court, among others.
And part of the issue here is I am unaware of a case either using a racial epithet or a slur or the word that was used in this particular case by the defendant that hasn't been addressed either by this court or the SJC in the context of what would be determined fighting words. Most of the cases addressed colloquial insults or swearing, but nothing of that particular nature. And so the only case that I came across was that United States Fourth Circuit. Unless there are other questions, I'm happy to rest on my brief.
All right. Thank you, Counselor. That concludes court for today. I'd like to thank the clerk's office. I'd like to thank the court officer. I'd like to thank our timekeeper. And, of course, all the attorneys that have presented in front of us today. And with that, court will be adjourned until 2 p.m. today.
Thank you.